What's up, everybody? I know, 1 minute late. It's better than Mike. He's like 30 minutes late all the time and you guys don't complain. Am I not worth waiting 1 minute for? Do you know who is worth waiting 1 minute for? Pups. Pups got bones, so they're just chilling. I mean, we could just sit here like this all day and watch the pups. Right? It's cool. It's all you guys care about. You don't like looking at me. How about this? Someone that's almost as cool as the pups, not quite. It's about the same color as the pups. But don't say that G word, you might get a little upset. He is back from vacation, folks.
Hey there, Meg.
The incredible JRobineLaw.
My pleasure to be here. We've got a really interesting topic today.
What he means by really interesting topic, hold on, let me see. Yep, they demonetized me already. He means shit show. We have a SovCit shit show. Hey, all. I'm kind of excited. I haven't done this in a long time, so I am very, very, very happy that we get to do this. And boy, do we got a crazy one for you. So I don't really know how to even summarize this one.
The best way I could probably put it, having watched it, is entitlement at the highest level. You know, big fish in a small pond trying to throw weight around. It's kind of remarkable.
Oh, mighty spork. Yes, it is. It's like a SovCit entitlement sandwich.
Yeah, it really is.
He is. He was hiding away on a beach somewhere or something, but I found him. I brought him back.
Something like that, and I will get back into the game. But yeah, I had to take a little bit of a break.
But I needed a little legal help with this one because an 18-page complaint was a little bit too much for my brain.
Oh, come on. It's a pro se complaint. What's the worst that could possibly happen?
I saw the misspellings and it was just like, okay, that's enough. So, ladies and gentlemen, this is Miss Karen Phillips. She is the county clerk in Smith County, Texas. Smith is near Tyler, Texas, in case you're wondering. She is married to Mr. Terry Phillips. He is the county commissioner in Smith County, Texas. Now they have a son. They actually have two sons that I know of. They might have more. And their son seems to have fallen into the sovereign citizen lifestyle just a bit. To set this up, what happened was the son and his friend were apparently out somewhere, and the friend was driving and was pulled over for a traffic stop. And this is the body cam footage from the traffic stop. So we'll stop it a couple times to talk about it, but there really isn't much I can do to intro this anymore. But take note of how long it takes him to pull over for the traffic stop. That's why I left all this in at the beginning.
'68 traffic.
We all need a break sometimes.
Robert George Mary 4057. We're pulling into 135 County Road 37. Hello? Sir? Yeah. You got a driver's license? I'm Deputy Peters with the Smith County Sheriff's Office. Reason for the stop today, your tail lights were not working as you were driving on the road, okay? And then you immediately pull into a residence.
I literally have a claim that taillights are not a crime I'm not involved in the traffic code. I have a notice here. I literally have a lawsuit going on with Nassau PD.
Okay. That was a whole lot to unpack all in one little nugget right there. Where's my notes? How am I supposed to unpack it if I don't have my notes? Jesus. Talk about unprepared.
Well, I can jump in for a minute. It appeared to me that they pursued for a period of time, and they're going to get into the SovCit stuff, but they basically pulled into their family driveway and decided, yep, now I'm home base, I win, you can't pull me over anymore. And that's just not how that works. You still committed a crime in vision of a police officer while on the public highways.
So this is the friend, by the way. The friend says he has a lawsuit with the Nassau PD. And the only Nassau I can find in Texas is Nassau Bay, which is a city that's actually in Harris County, Texas. And there are no lawsuits associated with this gentleman in Harris County, Texas, or in any federal court system. So I'm not thinking that he really has a lawsuit about taillights. Second, he's claiming taillights aren't required. Okay, we're not even going to touch that one. And he has a sticker on the back of his car. I tried everything to get a picture of this sticker. I wanted to see what this sticker said because I just need to know what the sticker said. But he has some kind of bullshit SovCit stick on the back of his car. I don't know what it says, but, you know, he is very excited about this sticker.
Yeah.
Hey, guys.
Yo, Credence
and Mikey are in the house.
I've been really enjoying your content, guys. Keep it up.
Yeah, if you guys haven't checked them out, click on their name, go straight to their channel, and hit that subscribe button because they've been pulling out some crazy TPO stuff lately, let me tell you. I don't even know what to say about some of the stuff they've had lately.
And signed by the judge. This is his dad's house.
He's also not driving. Driving's a commercial.
And I'm not driving. This is the county commissioner's house, county clerk. We just pulled in. Which tail light is that?
It was both of them.
Which one?
Both of your tail lights. None of them were working as you were driving on the roadway. Do you have a driver's license, sir?
I'm not driving. I'm outside of your jurisdiction, actually. Who do you work with?
The Smith County Sheriff's Office.
The Sheriff's County?
Yes, sir. Do you have any form of an ID or driver's license?
I do, but I don't have to present it since I haven't.
You do at this point in time because you have committed a traffic offense. You were driving a vehicle. I'm not here to argue with you. You have a driver's license.
I've got a dictionary real quick because he doesn't seem to know the definition.
I'm not involved in the traffic code. Yeah.
So the definition of driving versus the definition of traveling, there's a dictionary.
Okay, let's use this term. You were operating a vehicle on a public roadway. I'm not, sir.
So that's the son on the other side of the car, and this is the friend on the left side. And I actually had to look this up because I was a little bit curious about it. And this is a big SovCit thing, and I guess it's a little bit hard to read, but traveling versus driving are two different things. And the main argument for that is a private man or woman has the inherent and inviolable, say it for me, John.
Inviolable.
Yeah, big lawyer words. That's why I never went to law school. Right to travel. The common law acknowledges that a private man or woman has the inborn right to travel the nation's roads without the requirement for a driver's license or a registered vehicle. And they cite a bunch of very, very, very old laws. And they pick out certain verbiage that fits their needs on this. And it's not the intended purpose of those.
No, of course not. And I mean, a lot of these cases really, if you go back to them, I'm not sure exactly ones they're citing here, but a lot of them essentially were related to fugitive slave laws. They were related to kind of a darker history where the federal government was trying to impose the idea that you could move between states without being encumbered. And a lot of it was public accommodations. I forget the name of the case, but there was a huge one where a motel would not allow African Americans to check in. And the federal government determined that was clearly illegal because it violated the ability for individuals to safely and comfortably travel amongst the states.
So they take that with
To
this
an
intended
extreme.
purpose and try and make it fit their ridiculous.
Yes, and to some extent, that is a little bit of what lawyering is trying to pull inferences out of a case that maybe it's not 100% on point, but it helps your argument. But this is far and beyond what any attorney would consider appropriate use of previous case law.
Well, and it also seems like here's the road with the precedent that's set for this type of infraction, and they're way off here trying to grab something that has nothing to do with it.
Precisely. I mean, it's the point where, it's such a reach that you fall off the cliff.
Yep. That is a great way to put it. I wish more of them would fall off the cliff, though. Sorry. That's appropriate. Okay. Let's see what these yahoos are up to. And that should have only been a second long. Come on, play.
He's right now. He is being stopped. Okay, you have no involvement.
Okay. Well, actually, I'm actually just being a concerned citizen because I know that
That's
cops
fine.
kill people.
Okay.
So I'm actually just watching.
If you want to be a
Make sure you
concerned,
don't pull the
if you want to be a
It's
concerned
okay.
citizen,
Right
add your
now,
car,
I'm
please.
showing you the law.
Okay.
'Cause this is actually case law. This is case
Okay.
law showing
That's-
you the difference
and that's
between
fine.
automobile and a
That's not that right now. That's not where we're covering.
You actually don't need to know.
You have a driver's license. I can get
Hey,
you
what
out of here.
emergency do you have? Because if there's not actually a crime or a victim, then you
You're
actually
actually
can't even use
trespassing,
your
too.
red and blue lights.
You're actually trespassing on private property too.
Okay.
We need to see a supervisor.
You were operating on
Not
a
operating.
public
Stop using
roadway.
that terminology. You're
You're
lying.
incorrect.
Stop
You're
it.
lying on
You
the
have a
Stop
driver's
lying.
license.
Get
that
your
I can
supervisor
see.
here for
Can we
lying
get your
right now.
supervisor
You're
here?
actually
Not
lying.
at this point in time. If you can provide me with your driver's license.
I'm not. I
Not
You
will.
have a driver's license.
Yeah, not driving.
I don't answer
Not
questions.
driving. Don't answer questions. Get your supervisor
Yes,
here for lying
you are.
on the record. Golly.
68. Can I
What's
get
your
a
name and
101?
badge number? You're literally lying right now. On
Okay,
the record.
right now you are being placed. You are detained.
Whoa.
You are being detained.
Hey, he does not
Right now
consent.
you're being
Help me.
detained.
Okay, what is
Stop.
Give me my license.
Stop.
Let me have this. Bro,
Would you mind pausing for one moment?
Wow.
Right now you're being detained.
Illegally detained. Help me, bro. Illegally detained.
Give me your other hand.
Dude, you're gonna be losing your job. You're getting sued. You're getting sued, dude.
What have I
You're
done?
losing your job.
Right
No
now-
crime has been committed. Can you please help me?
Right now I am detaining you, failing to ID.
Here, can you look it up?
He's literally not committed.
I can, but you're refusing to offer it to me.
He's arresting me for failure to ID.
Right now you're not being arrested.
He's saying he's taking me as Karen.
Right now you're not being arrested.
What's your name?
Sir, step back.
What is your name?
Step
Shut
back.
the fuck up. What's
You're
your
about to
name?
get detained too. Step
Hey,
back.
can you pause 1 second real quick?
For failure to
One
ID.
second. Watch.
Right
When they
now,
show
like I
his
said,
hand.
you are not under arrest.
He's not
You
here
are
for
being
his life.
detained.
You can't really see it, but his hands are like shaking like this. And I just wanted to point it out because they make a really big deal out of it later.
Okay. So there are 2 points that I wanted to bring up. One was actually brought up in the chat.
That he's an asshat and he's an even bigger asshat.
Well, that goes without saying. But one, the argument
Amen,
that,
sister.
that they're trespassing, absolutely not. They are in an active engagement of at this point, violation traffic stop. And just because you decide to pull into your driveway doesn't mean that you're suddenly home free. It doesn't work that way. They already have reasonable, articulable suspicion in order to detain you. Period.
I know
That
someone who
goes
got a
without-
DUI in his driveway.
Yeah.
Literally drove like an eighth of a mile down the street and got a DUI. I
I've seen somebody in a
Nothing.
motorized tricycle get a DUI in their driveway.
Didn't Bill Murray get one in a golf cart over in Sweden or something? That was a while ago.
Nothing like that. I vaguely recall that one. But in any
Yeah.
event, your driveway is not home base. It's not like you touch it and suddenly you're free to go. It doesn't work
And
that way.
I think they were he's doing it because of that entitlement factor. The way he kept saying, you're getting fired, you're getting fired, you're getting fired. He's like, my mom is important, you're getting fired, which I can't wrap my head around the fact that his mother is the clerk. And the clerk in the town handles like all of the records, like all of the recording, all of the things that he is so against. Like, I'm not registering for anything. I'm not doing this. And that's what his mom does.
Yeah, I mean, there's that. And we'll get to her complaint, but she almost basically repudiates her own job.
Yeah, I don't know.
But yeah, and then this one would be the gentleman recording. That's Cody, right?
Cody's the one who's getting the handcuffs put on him right now.
Okay, so
we're looking at the body cam of the officer.
All right, so Cody's the one getting the handcuffs on, and then this is the brother.
Derek's standing next to mommy.
Okay, gotcha.
At the front of the car right now.
Okay.
Yes, the brother doesn't appear in this one. He's later.
Gotcha.
But it escalated so quickly. Like, all you had to do was show an ID, and I guarantee you, the cop would have said, "Hey, dude, your taillights were out." Oh, I didn't know that. I will go get them fixed tomorrow. Okay, have a good night, sir.
Meg, I literally, over the course of Easter, I was driving to North Palm, and I had a rental car. And I pulled off when I got to 95 because my GPS wasn't working. So I pulled off on one of the exits. Cop lit me up. The taillights were out because I didn't realize that you had to manually turn them on in the rental. I said that, gave him my rental agreement, my license. We were good. He said, don't worry, have a good day. It's that easy.
Aren't those things always automatic?
I always thought they were. But
I wouldn't know what to do if they weren't automatic anymore.
He's like, all right, they're working out. You're good. Have a good night, sir.
See,
that's all you got to do.
You get back what you give, and the fact that they're being such asshats is what's causing this situation. And you could see the cop's hand shaking like this, and I'm like, I can only imagine the amount of adrenaline rushing. He's by himself. It's dark. These guys are jumping out of the car, being confrontational, 2-on-1, and then more people are coming out of the house.
Situation. You don't know if they have a weapon. I mean,
outside of anything,
traffic stops are the second most dangerous events that a police officer can undertake.
And later on, he's giving him a hard time for being scared. Well, no shit. I would be terrified. I mean, it's like the big unknown.
Everybody in that circumstance is probably uncomfortable, but there's a way to do it without escalating. And it seems like the cop's trying to de-escalate the situation, but they're not.
The cop kept his cool so much. I mean, I
agree with you.
I had a mama bitch slapped the kid the way he's talking. Like, get a dictionary, please.
Yeah, well.
Hey, okay. That's the same thing. That's the same thing. I don't consent to any searches.
His taillight was out. His taillight was out. So now he's
allegedly.
His taillight's out.
Please, I do not.
Look at that, Mom.
I'm sorry. Can I ask what's going on?
Right now, he's being detained because he failed to ID. What I'm trying to do is get his ID because he was driving a vehicle.
No, he's not driving. Now you're lying again.
Sir, this is not about you, okay? This is with him.
You keep saying the wrong thing.
Where's your driver's license?
See him shaking.
Okay.
Under duress. Can I get it for you?
Where is it at?
I think the officer's genuinely concerned.
Where's your driver's license?
Shaking and it's making me
Where's
nervous.
your driver's license at?
It's making me nervous. Under duress, it's in my pocket.
In your pocket.
But I'm not.
So notice he keeps saying under duress, under duress. I'm under duress.
No shit, you're being given. Sorry, I told you I wouldn't curse, but
no, it's okay. We've said the small words. We're good. I'm sure I'm demonetized. I get demonetized on every stream now.
But no kidding. I mean, look, of course you're under duress. You're being provided a lawful order. That's not a friendly request. That's not a, hey, do you mind doing this? Of course it's under duress. You're literally being ordered to do something that clearly you don't want to do.
Is verbalizing that, though, continually throughout the process, doing anything to help his defense? I mean,
no, not at all.
Because he's...
Not at all. It
I
can
would
it can
say-
help you. It can help you when they first request to search and you refuse and they keep going and you identify that it's under duress. Perhaps that can be helpful, but it's honestly better just to shut the hell up and let the body camera speak for itself.
I would think if you were being threatened in some way, or, you know, there was something bad going on, the cop just asks him. And he doesn't even, there's no force. It's not like he's holding him at gunpoint saying, give me your ID now. That would be under duress.
Yes. But no, when it comes to police encounter, duress, like Mr. Fun said, duress is essentially...
With the spoilers. I can't say your name. I get my tongue tied.
But yeah, screaming this is under duress, no, that has absolutely no legal effect whatsoever.
Okay.
Nobody cares what you actually have to say unless you incriminate yourself.
It just
And
makes you
by
look
the
like
way,
a
I've said this
whiny
before,
ass.
and people who have been frequenters of my channel, nothing you can say can help you. It can only hurt you under the rules of evidence, because a statement against interest is an exception to hearsay. A statement in favor of yourself is hearsay. So it can only ratchet one way.
It can only hurt. Gotcha.
Yeah.
Put the frozen stuff away and let the rest sit on the counter for a while. You'll be fine. All right.
I'm not giving you jurisdiction because I'm not operating under the commercial
Okay,
code.
we're beyond that right now, okay?
All right, under duress, when I'm in handcuffs, can you please get it?
Yes, where is it at?
And you're shaking, it's making me nervous.
Where's your driver's license?
It's in
Can
my
I
pocket.
ask
It's in your
why
pocket.
he's in handcuffs?
Because right now, when I stepped out of the vehicle, he refused to ID. Okay, what I'm trying to do is identify him. Once I get his identification, so I pulled him over, ma'am. Ma'am.
Wait, I want to ask this.
Okay.
Do you have a way to check his ID through a license
good.
tag?
No, I don't.
Do you think she's
man.
drunk?
You have a computer in your car?
Because I kind
I
of
do
do.
have a computer in my car,
You
but
have
it
a
does
radio
not
on your
link
chest where you
with
say your
the
license plate number?
license
The way
plate.
she's speaking.
Okay. We're gonna step back over here so I can get your ID.
Dude, let him drag you. You're not non-compliant.
Like
Let
I've
him
said,
drag
look,
you?
They're causing issues beyond the
Why?
point of what needs
I'm
to
not
happen.
running.
Okay?
I'm not.
You're
Yes.
not.
Can you
I
at least put the
said
handcuffs
you
on
are
me?
detained right now. Can I see your
For
ID?
what crime?
Can I see your ID?
If I'm detained, then I'm under.
You said it's in your pocket?
Because he's in fear for his life. What a joke, Peter. Dude, you're fired. You
All
are
right, man.
fired, bro. Losing your job.
Sir.
Who the hell are you
Sir.
to say that?
You can step back by your car.
You're not even talking about
entitlement
it. Don't say
issue.
sorry
Just
to
lean
me.
up against this
You're not
car.
in fear
Can
for
you
your
give him the
life.
keys?
You're on my property.
I'm not taking the keys.
So this is the entitlement thing again. You're not in fear for your life. You're on my property. You're losing your job. I mean, I'm surprised he hasn't thrown out mommy and daddy's name yet.
Well,
He
but here's
hasn't
the thing
said,
is,
do you know who I am?
who's on a practical level threatening whom? I mean, he's the one that's throwing threats at the cop.
Oh yeah, continually.
And I think the cop's being extraordinarily patient with the whole matter.
Unbelievably. The thing that kind of blew my mind, I thought these guys were like 20,
Yeah.
you know, younger, just barely getting into adulthood.
Nope.
No, Mr. Phillips is 37.
And he's more than 6 years older than I am. And this was about a year ago, so
Yeah, we're not going to talk about how old
yeah, well, fair
I
enough.
am.
I'm willing
Oh,
to
I'm happy that
no.
the pups make everything okay. Yeah, this just keeps going. So we're just going to keep going because it gets worse before it gets better.
It doesn't get better.
I'll put them back in your pocket, okay?
Are you really gonna arrest me?
Disgusting.
Are you serious?
I've said this multiple times. You're not under arrest. I detained you because
It's
you
the same
failed
Do
to
you want me to
ID.
see if he's single?
You don't get the dictionary.
Where's your license? Because I'm not trying to go all through your wallet.
I don't consent to a search.
I'm not searching.
Could
Where's
you
your
unhandcuff
ID?
me as a man, and I'll give it to you.
Once we're complete with the traffic stop.
It's not a traffic stop, man.
It is a traffic
You're really
stop.
gonna get in trouble. Can you talk to your supervisor? It's a traffic stop if I'm a U.S. citizen.
Okay.
I'm not a U.S. citizen.
Do you
I'm
have
a
some form of an
non-resident.
ID?
I have
do.
no weapons. by
You
the
said
way.
it was in your wallet, correct?
No weapons on me. I'm just making sure you don't kill anybody tonight.
You're scaring me.
You've
dude.
already-
I wish
you're
you would just talk to
already
me like a man
illegally
and I could
detaining
explain
somebody
things.
for
to
no
you.
What have I done that was disrespectful to you?
No
You grabbed
crime
me. You're
committed.
shaking my hands. My hands are in handcuffs. I haven't committed a
What
crime.
crime do you suspect is being committed right now? Do you know the definition of a crime?
Is it in your wallet? Your
Oh
ID?
Lord, we're getting to SovCit.
You're searching his wallet?
That
Oh
is
my
an awful
God.
procedure. I don't-
Cody, would you like me to
Okay.
get it out of your wallet for you? I can't believe you wouldn't give him permission to search your stuff, would you?
No.
Do you want me to get it out for you?
Under duress, if he's saying that he's not gonna let me go on list, then you can present it to him. Yeah.
Oh, okay. Oh. Yeah,
Can you tell me where your ID is?
Right?
A minute ago you said I could take it out of your pocket.
I don't answer
Under
questions.
duress because you're handcuffing me.
Okay. Yes, because
Yes,
I
you're
told
being
you are detained
detained.
at this point in
ID's in my
time.
wallet.
Pursuant to
Okay.
a traffic
ID's
stop.
Where is it at in your wallet? I'm not trying to go through every single card you have. This is it.
He's going out of his way to not search your
Okay.
belongings.
This
just
is
wants to
driver of this
verify
car
that you're
causing an
valid
issue.
license.
I'm not a driver. I'm not driving.
Hey, no, you don't tell me what to do. Get off my property.
You interjected yourself into the
Hey, no, get off my property.
Get over here now.
The way he talks reminds me of like a toddler, like young preschool age kid. I'm waiting for him to say, "You're not the boss of me."
Yeah.
Wait till get him in handcuffs.
Excuse me, sir. Are you the supervisor?
No, I'm not.
Okay.
Get away from me.
You're interjecting yourself into this traffic stop.
Get off
over
my
here.
property, you piece of shit.
Get over here now.
No, you get over here then. He wants to say get over here like I'm a
Okay,
dog.
I will get over here.
Yeah, exactly.
What is going on?
Yeah, exactly. Get away from me.
I'm here.
Get away from me. Get away
I'm going now.
Get away from me. Get away from me.
Subscribe channel.
Stop! Help! Help! Help!
Give me your hands! Give me your hands now!
Help! Help! It's my glasses!
I got to
Help! Help! I have it on my back!
Stop.
Help!
Get back! Step back! Get back!
Help! 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 Mama, help! Take my phone! Take my phone, Mama.
We got 1 minute.
I'm asking you for some stupid.
I've done nothing. He's hurting my wrist. He's breaking my wrist.
Guys,
Get off of me. I can't even breathe.
Get back!
let him go.
Oh,
Where's
shut
my
up.
glasses? Give me
I got him.
Oh my
Give me
God.
my glasses. I can't. Stop breaking my arm.
Hey, go, get back! Step back!
Get my glasses. I
Step back.
cannot see.
Go!
You gotta stop.
His glasses are right there.
Those are his glasses, okay.
Glasses.
You step out with me.
Hey, you know what y'all doing?
What the hell is going on?
Help! Help!
Please let us go.
Help! Help! Help!
Hey, don't hurt him. He has not committed.
Ma'am, step
Let
back.
him go. You're hurting his shoulder. You're hurting his shoulder. You put him in the Kimura.
Crap! What is
I have your glasses. I have your glasses.
Get in my glasses. What's wrong? I've done nothing. Please record this. They're kidnapping me. I've done nothing.
I don't know what's going on.
Can we all talk like adults,
Here,
please?
you coming with me?
Please talk.
Hey, Rob, I'm putting him in my car. Come on.
Why do
Come
I
with
have
me.
to go in the car?
Because right now you are
have
causing
my
more
ID?
of an issue. Yes.
What did I do, man? You have my ID, dude. Can you run my ID at least, or what? What are you doing, dude? Why do I have to go in
I mean,
the
you
car?
did try to break
Just
away.
step in here, man.
There's
Are you
that.
serious, man?
Yeah, I had a pause coming up here somewhere.
Okay. I'll wait.
All right,
I
step
can
in the car.
talk.
What was your name? And badge number?
Step in the car.
Okay, there we go. So that made me a little uncomfortable. I'm not gonna lie. That was a little cringy.
Yes.
He yelled for his mommy as he was getting arrested.
Yeah.
Oh, hold on one second. John, take this. Judge Dad is calling me. Hello?
Yeah, so this is a question of hot pursuit. As I discussed with Meg, hot pursuit is a subclass of exigent circumstances. This is when you have probable cause to believe that a crime has been committed. In this case, it's probably fleeing and eluding. I don't know exactly what they end up charging him with precisely. But when you break away from a detention and try to flee into a residence, the cops don't have to stop at the threshold, because there is a reasonable likelihood that you are either going to destroy evidence or try and elude the detention. So in that regard, like I said, so exigent circumstance can be a number of different things. A classic example would be if you go for a drug search and you hear somebody start flushing the toilet. That can be enough for exigent circumstances. But hot pursuit in this case, you broke away from cops and you tried to flee into the home. They're not required to just stop their investigation at that point. That's just the nature of the reality. So in that regard, yeah, I think that they were probably okay. So Wombat Mommy, I cannot pull up your comment. Yes, he ran into his own home, his parents' home, while they were trying to detain him. But the reality is that's not the end of the detention. They have the ability. Hot pursuit, I don't like the term. I know a lot of people do. It's very common in common parlance, but it is a subclass of what's called exigent circumstances, where there is not enough time to receive a warrant in order to administer justice. That's the general term. The other example, you see it a lot in like cop shows where it's, when, let's say, marijuana is illegal and the cops say, oh, I smell marijuana, and they kick in the door. That one's less, it's more on the fence, not necessarily okay. But hot pursuit's a good one. If they hear screaming for help inside the residence, they don't need a warrant. They can go straight in to try and protect the person seeking help. There are a number of circumstances under which, yeah. So this guy, absolutely. And like I said, I can't, unless you're on my channel, I can't pull up your stuff. But yes, this guy is absolutely right. The classic example is somebody inside a home screaming for help. And you don't have to wait for a judge to give you a warrant to go in and try and help. This guy, not necessarily. In modern times, or at least in the last few years, generally speaking, you're right. That was used as a predicate for exigent circumstances for probably 70 to 80 years. So, 3VOM. It always amuses me that SovCits try to use their own definitions when it suits them and acts as if no one has ever defined things like driving or vehicle when drafting laws. Well, the issue is that they selectively pick definitions from statutes that are not relevant to the particular circumstance. So that's kind of the issue. So if you notice, they always say, driving requires that it be a commercial vehicle. And yeah, that is the definition under the commercial code. However, that has absolutely nothing whatsoever to do with this guy. Not true, just historically, but I understand where you're coming from. Yes, for a vehicle, it's much more common because the standard is lower than for a home, but it has absolutely been upheld. Particularly, like I gave the example, if you start hearing a toilet flush and you're there for essentially a drug warrant, that can be considered exigent circumstances, even if they don't answer the door. Even if you have a knock warrant, it does go that way. Wombat, you are on my channel. Unfortunately, because this is Meg's show, she has control over what comes up and what doesn't. Good to see you, Jane. And I do intend to start coming back. I have a couple ideas in mind. But yeah, it's good to see you all. Thank you so much for being here. And thank you so much for sticking around while I took an extended hiatus. I do very much appreciate it. So folks, let me ask you, do you think that the cops have behaved reasonably thus far, or do you think that they behaved in such a way that a lawsuit is appropriate against them? Yeah, this guy, I agree with you. If you have a choice, get a warrant. If you don't, then it's exigency. However, the law gives a little bit wider latitude to exigency than I think you're contemplating it. So,
Step in the car.
that is what it is.
Move your foot.
He's pushing on me. I have a bad back. He's hurting
I'm
me.
keeping you from turning towards me.
To talk to you, stupid. How stupid are you?
Stay back.
Who is this?
Help! I'm getting
Back.
kidnapped. I've
Sorry,
done
just stay
nothing
right there.
wrong.
Stay right there.
House. They ran in our house.
I've done nothing wrong. No crime at all. Nothing wrong.
Let's get him in the car.
No!
Yes.
I'm not going
Stand
with
up.
you. I've done nothing.
Stand up.
What are you doing?
Stand up.
I've done nothing. I've done nothing. I've done. You're hurting me. My arms are getting
We're
broken.
10-4. Still got one resistance.
Get me your supervisor now. I want a supervisor. Give me a supervisor. I need a supervisor. I'm being kidnapped. I've done nothing. I've done nothing.
Come on.
You're such a piece of shit.
That being kidnapped
I've done
thing is
nothing wrong.
going to show up in
Get
the
in the
law.
car.
Help! Ah, my arm.
I'll give you a hint. It's a loser.
We're 10-4. Anybody else coming, y'all can reduce.
Ma'am, I am more than happy to explain to you. I need to go back to my car.
I got it.
324, anybody who's calling around can reduce code.
68, you can go from check.
Deputy Peters conducted a traffic stop on this vehicle. I don't.
Yeah, I think Keith plus
I don't know if that's your
inline
son.
and probably about late right now.
Ma'am,
Son came out and is interfering with.
ma'am, would you like to accompany me so I can get my flashlight out of your
So now
out of your
this
house?
woman is the clerk of the county.
I don't think this needed to go this far. Over what was the traffic stop?
This guy, my channel is
Can you tell me
JRobineLaw,
what the traffic stop
Yes,
is
ma'am.
for?
So the
but I
other
took
person
a
who
hiatus
I was trying to
for a
conduct
while.
business with,
Cody.
Anyone in the
Cody-
chat can give you.
my flashlight.
I think she's drunk.
Is that it?
I'm
I don't
pretty
know.
sure she
I
is.
don't know which
Yes,
one.
ma'am, that's it. Which one of these are his phone?
This is Cody's and Derek's.
Okay.
Okay.
You want me to give it to Cody?
No.
Okay. All right, let's step back outside.
Which again, there's nothing illegal about being drunk in your own home, but thanks this guy.
You
I
okay?
appreciate it. My issue more than anything is throwing the weight around of her position. I find that deeply inappropriate. Mace window, probably wine or vodka.
Sorry.
Nah, you're
Sorry,
good.
sorry.
Don't apologize. It's okay.
Oh, Jesus. I don't even have my earbuds in. Okay, what'd I miss?
This was the first interaction between.
That was Judge Dad! He called me! Sorry. Hold on, fangirl. Woo. Hold on. What an absolute sweetheart. Okay. Okay, yes, real quick. Judge Dad called. I saw, tell us about the call. Judge Dad did not realize how popular he was. He was blown away that he was so widely known, and the Judge Dad thing was shocking to him. He did not think he was doing anything extraordinary, but he is very thankful that we are doing things like this because he thinks it is incredibly important that we are supporting our judicial system and everybody is understanding it and seeing the workings of it, because it is one of the fundamental support structures of our future. And it, God, I love Judge Dad.
I would say, as a practical matter, the judiciary is the. It's kind of strong to say last uncorrupted, but it's the least corrupted that we have left. So it is.
I told him Maria, I told him, I said, do you know, I'm actually live on YouTube right now. I said, don't worry, everything's muted. I said, but if I was to unmute and tell them that I was on the phone with you, I said, there would be 140 something people freaking out right now. He's like, no way. I said, yes. He was quite surprised that it was that widespread. The love went that far.
Oh, guess what? I just got demonetized too.
Sweet.
I know.
We broke together. Love working for free.
Welcome to the club.
But he he really didn't realize how big of a deal he was online. And so I sent him a little, I do the little wood cutouts. I sent him a little thing for his desk that said Judge Dad with a letter that said, hey, I'm sorry I made you an internet sensation. I hope that's not why you quit streaming. And he said, no, that's not why he quit at all. So really awesome conversation. An absolutely amazing person who truly cares about the justice system and about the people that are going through his courtroom. And that's, I'm not going to say rare because there are a lot of judges who care, but it is not every judge that cares.
Yes. And I will say, as a litigator, knowing your judge sometimes has to be forefront in your mind, even beyond the law. It just is what it is.
Boy, whew. My heart's going like 1,000 miles an hour. All right. Are we good to keep going? I was trying to give you hand signals, but I didn't really know what to do to see if you wanted to play.
No, we're good. I think, like I said, they just confronted her. She's been drunk.
I'm not doing it. I'm not going anywhere.
You already did do it. Put your foot in the car.
Please, my cuffs. Please. They're breaking my wrist.
We'll check them in a second when you
Just check
calm
it right
down.
now. I'm right here. I'm not doing anything wrong. Help! I can't breathe.
Are you okay, ma'am?
No.
Okay.
This is too much.
Yes, ma'am. I'm not being funny. Do you need a paramedic?
I don't know.
Okay.
So, what this guy did?
So,
See, you guys were, oh, motherfucker. I hate this. The way this video is, when you hit pause, if your mouse isn't perfect, it takes you all the way back to the beginning.
That's all right. Well, you look for that. I think that it's actually very interesting because the cop is trying to be as polite as humanly possible. He recognizes that she's hysterical.
But is she drunk or is it anxiety? She's freaking out because all this is happening? Because she came out to them getting arrested.
I am relatively strong on my opinion that she's intoxicated.
Okay. I think this is.
I don't know for certain, and obviously, I can't prove it. But Sushina made a good point. Drunk plus anxiety is a panic attack. It could be something in that ballpark.
Ma'am, do you need EMS?
Standing right here.
Do you need EMS?
You need EMS?
I don't think so. I was.
Will y'all please run my
21, can you go ahead?
Yeah, you don't get that inconsolable when you're sober.
Put your glasses. Okay, so just so you're aware, you are under arrest.
Thank you, Debbie.
What crime? For interfering
Plus that YouTube requirement for the commentary channel.
Hey, Derek. Hey, Derek. Have you ever had a Texas driver's license?
I have it before in the past, yeah. I use my Texas travel ID though. Is the ambulance on the way? I believe I'm bleeding.
Yeah, they are. Yeah, you do
I
have
think that Iris, I agree with you. I think that argument
they're on the way.
can beat the death of
Is
this.
your supervisor on the way as well?
Our supervisor's already here.
Can I speak? Is it a he or her? Or
You don't need to speak with him.
I don't get to speak with a chance to speak with the supervisor. Why do I not get a chance to speak with your
I can go ask him if he wants to speak with you,
Yeah,
but
I'd like
no,
to-
we're not required to have you speak to our supervisor.
No, I know you're not required. I'm asking.
I'm more than happy
68.
to go ask him.
Hey, Cody. Hey, who is?
So just so you know, from this point on, I chopped the video up some because there was really long stretches where they were just walking around staring at the back of the car, or the officers were talking to each other about what charge, and it really wasn't relevant to what we were talking about here. So if it looks kind of choppy, I did that. There is the full video that's out there, and it's on that. I'll put the link in the description. The K something news and the CBS 9 from Texas.
Thanks. And if you can send that to me, I'll throw it in my description as well because I have to do it separately.
Oh, that's right. You have to do it separate. That's so weird.
I know,
These people.
but it is what it is.
That's Terry Phillips and Karen Phillips.
Okay. Are you okay if you leave the vehicle with them?
Are you taking us?
Yes, so right now you're under arrest, and so is Derek.
For what crime?
For failed ID.
You had my ID.
Okay. Are you okay leaving the vehicle here with them?
Yeah, they can have it. It's not a vehicle though. It's an automobile. I'm not involved in commerce. I told you guys.
I'm not gonna argue tonight.
Okay.
Hey, can I speak to you? Look, I know. Hey guys.
Where are the keys at so they can move the vehicle?
You had them.
I put them back in your pocket. Are they still in your
I
pocket?
can't tell these handcuffs.
Okay.
I thought you put them both on your hood. Oh yeah, it might be there.
I'm gonna give him the
Give
keys.
it to Terry. Yeah. So you're taking this both?
236, can you take this public service for us?
It really was a simple question. Can we leave your vehicle here? And it's got to turn into an argument. But then he's like, well, but why are you arresting us? Well, hello?
I mean, there are a lot of times where I see officers claim resisting or eluding in ways that I think are not appropriate. I think that's pretty appropriate in this circumstance.
Oh my gosh. Like,
You escalated it from a simple taillight violation, which is probably, what, $100 ticket?
I bet he wouldn't have even wrote him a ticket if he would have just pulled over.
Yeah, to all of this. None
What
of
do you
this
think
is
on him?
necessary.
Just resisting and interfere, or?
Yeah. Yep. 100% interfering.
Oh yeah, no, without a doubt.
You resisting? Yeah. Oh yeah.
But I didn't know if you want to do evading too, or.
No, I'm not worried about the evading.
All right. Where'd they go?
So I think in Texas, and I'm not 100% certain, but for resisting, you need use of force or threat of force. And I think him breaking free and running into the home, that probably qualifies as a resisting charge.
Okay.
Because that to me is application of force.
Yes, there is the son and then the son's friend.
Yes.
So the son's friend was the one pulled over, and the son is the one who's instigating the whole thing and turned this into like drama.
Here are the keys to this car. I don't know what happened with this.
I think they're
This
in
key.
his pocket or something.
Okay.
Derek's got a few things on his person that he'd like to give you guys. Doesn't want to go to jail with him.
Yeah.
Are you okay with that?
Yeah.
Okay. We'll pull him out real quick and grab that stuff, and we'll get to you. Okay.
Right?
The father seems very reasonable, actually.
Hey, do you want your wallet to go with you as well, or do you want to leave it here with them?
Another simple question.
69, son.
I don't know. Did Derek take his wallet, or is he leaving it here?
What's Derek doing?
Who
I didn't
cares?
get to that chapter in my SovCit handbook.
I think he's leaving it. I don't know for sure.
Yeah, I don't know, because
It's-
y'all.
I mean, we can take it with you to jail. That's fine.
Well, I don't want y'all to be.
Would you like it in a locker in jail, or would you like to leave it
It's your
with
wallet, man.
people you know?
It's
I know.
whatever you
I
want to
just
do.
don't think it was right. Like, I mean, you could have just given me a citation, and I
Okay.
could have. Like,
24.
We're beyond that now.
what are y'all getting him for?
Interfering with public.
How were they
Read the
supposed to
OM.
give him a citation? They didn't know who he was.
Right, he wouldn't identify himself.
How can people sit there and actually say this and believe it? Like,
I know-
you
I know.
know what you just did.
I know, and my people are pointing out that this is
Yeah.
a fix-it ticket. Literally, it's just get your taillight fixed and we'll dismiss the charges. It probably wouldn't even cost them anything.
Yes, this is the commissioner. Dad's the commissioner.
He's the,
For the county.
I think, 4th precinct commissioner for the county.
Third.
Okay.
And mom is the clerk for the county.
Went into his.
He looks
house,
like he just woke
got
up.
a warrant. And,
Okay, I guess the wallet's gonna go with you to jail. That's fine.
broke the law, and you think you're not.
Okay, so they did a lot of talking, figuring out what's going on, and then in the back of the cruiser, the friend, this is Cody Voss, this is the friend, ran his mouth the whole way to jail.
Yeah.
So there was a ton of background noise and everything else, so it might not sound perfect, but I enhanced the audio the best I could to try and get it to where you could hear what he was saying, because I thought during the traffic stop, he was the more reasonable of the two. He wasn't quite as belligerent as the son was. The son was pretty belligerent, cussing at him and calling him names and things like that. Don't you think? No?
Yes, except for the fact that I don't know. I feel like their energies played off of one another. I mean, the son, what is it? Peter's last name? Phillips. Yeah, he jumping out with the phone, trying to stir something up. I think probably escalated the situation. Wombat Mommy asks, "How drunk are they?" I don't know that they actually were. I think the mom might have been. I'm fairly certain on that one, but I don't know that the two guys in the car were. I think they were just, I don't know, out of their minds.
So let's listen to this jackass.
Held accountable for law. My buddy told you he was a cop for 10 years. You think that you know the law? You don't know the law. You're a jerk. You're a jerk, bro. Think the law doesn't apply to you, and it does, man. You know, you're held accountable with you know acting with it. I'm not signing shit. I don't consent to you. You don't have any jurisdiction over me. I'm not signing. I don't authorize anyone to represent me, and I'm competent to present myself. So, I already told you, man. You're shaking, dude. Like, really, if you're grabbing me and shaking, I can tell that you're nervous, bro. Bro, you're grabbing me and you're shaking. You're supposed to be trained for the situation to de-escalate. You don't escalate it. You were freaking shaking when you were grabbing, bro. I wasn't trying to resist or nothing, bro. I wasn't doing nothing, bro. I was just
I mean, in fairness, it was a 4-on-2 confrontation.
Sure. You didn't even give me the opportunity to sign a citation, man. This isn't a jailable offense, dude. First of all, I'm gonna do a request for your body here. You had my ID, and then you're writing on a document that I didn't present that. That's falsifying a government document, and it is fraud.
No, it's
and
not.
I'm basically be filing a claim against you at the district court. So, as district attorney, you're gonna be in trouble.
Oh my God! Please shut up.
It's like her, right?
It goes the whole way to jail. It gets worse.
Your power, but guess what? He wants later, you're gonna get the wake up call. I wrote the paper for those. We're peaceful civilians, man. We know our rights. And you had no right to do what you did, especially if you didn't do anything wrong. You have my ID. The other officer came and escalated the situation. You have my freaking ID in your hand. What are you talking about?
They did everything they possibly could to de-escalate the situation.
You're not saying that things you know.
Are you kidding?
But you're too deep now. Now you're gonna have to get it. It's gonna have to play up full thing.
Do you not realize that they have video too?
What I would give to just knock the shit out of this kid.
My training agency, that's why I can tell when there's a freaking nervous little fucking pussy who's shaking, grabbing my arm. You're supposed to be a sheriff, but you never trained in your life, bro. I can tell by your body type or fat. Well,
And a very good made by one of the commentators. Adrenaline is going to cause you to shake a little bit too anyway.
That's bad. But guess what? You're fat, dude. And you shouldn't be in the position that you're in because you were shaking over a simple, what you would say, an alleged taillight out. You're shaking with me in handcuffs.
Anyone who says I know my rights
training at all. Because I took my training officers all the time, and I can tell there who's calm in a fight and who's not. You see what I'm saying? And that's what I'm sparring. That wasn't even any kind of fight or altercation. Just a calm little thing, and y'all escalated out a chicken hand, man. Y'all hurt my friend, and I am a witness to that. Y'all put him in arm Kimura, and I seen it.
Basically, there's a reason why they let him run his mouth.
Y'all think y'all
All
have
the
right to go
videos that filed.
Let him look at something happy, because this guy's
Big
making
man.
him all mad. Say calm. Calm. Send him calm vibes. Look at them, not me.
You're really gonna make us spend the night
That would be
Jam.
funny.
over some stupid shit like that, bro? You really think you're upholding any kind of goodness, bro? First of all, your corporation is not getting no money from us. None. None. You ain't getting signatures, you ain't getting nothing. The only thing you did was inconvenience 2 men like yourself. Because guess what? You don't have no fucking authority over me, dude. Just like me, man to man, I'm not scared of you. Bro, you're a cop. Bro, good fucking luck, man. You ain't shit to me, bro. And I guess what? I'm not fucking intimidating you in the slightest, bro. Matter of fact, you're gonna lose your job, probably your car and your house. Civil, I don't know if you ever had a civil
Piece of
suit,
shit.
but you really messed
Well,
up.
we
dude.
be telegraphing what we're
Oh,
doing
man,
next.
it's hilarious. It's hilarious. I can't wait till the constable serves you, dude. Can you imagine that? We're getting the body cam footage. We're gonna put up all the case off.
Pause for 1 second.
It's almost done.
All right. Just real quickly, when we go to the actual federal complaint, how much case law do you think they actually cite?
Oh, probably none. A couple of their whatever's in their SovCit handbook.
All right. We'll get there.
Trespass into the county commissioner's
Then again, probably a
house.
lot. I don't know. That could go either way.
They did file a law.
And without a crime, right? Without a crime. Wow.
I
Crime, by the way,
probably
is
not.
defined by the Supreme Court as the injury to a party for their property. Guess what? There was no injured party. There was no victim. Therefore, no crime. That's the Supreme Court. That's common law. That's the highest law of the land. It goes above all your little bullshit.
The high law of the land.
Ah,
Bring in.
never heard of it.
Bring in. Sure.
And this isn't the son. This is the friend, right?
Yes, this is Cody
You
Voss.
surprised?
Yeah.
If you
He's
just
not
stopped
even
without
named
proper
in the
thought,
lawsuit.
said it was
Although-
the lights.
We'll get there.
Never checked them. Never got me an opportunity to look, and that's what that kind of. That's a traffic violation. Oh, do you know the difference? I'm gonna educate you right now, son. One involves a victim. One is only applicable to U.S. citizens still in contract with the corporate United States, which I am not.
Wombat Mommy, thank you for the $5. I absolutely agree with you. But he seems fundamentally incapable.
Ain't nothing wrong. And so guess what, dude? God sees all things, man. I don't care if you believe or not. God sees all things, man. What you think you did tonight? Right? And I know you're framing it like this, right? I know what it's like, right? You frame me as like a customer, right? Oh, you're just at work and I'm another customer, right? I get it, right? I know business
Yeah.
better than you could ever even
exactly what
imagine.
it is.
And guess what? I wasn't involved in no commerce tonight.
Yes.
So you messed
Those
up.
white
dude.
noise machines.
You don't need it to learn anyway.
The Japanese actually created a silence gun. I think I told you about that. It basically repeats your words back to you about a millisecond in delay.
You're just dumb.
and just
You don't
confuses
realize
your
what you've
brain.
done. You must not have been in that position for long. You must not know very much of the law. Oh, that officers that do break the law, you think you're not held accountable? You think you're not held responsible, dude?
He just doesn't stop.
Kidnapping,
The whole drive.
assault,
Kidnapping.
falsifying a document, unlawful search and seizure,
Uh-huh. I saw none of that on
breaking
my
and entering, out of warrant,
If somebody did, correct me if I'm wrong.
Yeah, no.
using emergency lights outside of emergency, felony. You know, most contract in the day, so you're done. No, make sure you get that fixed. But put myself like work. And a traffic violation is not a crime, so I wouldn't have to teach you my ID. Which I did, and then you're still taking me in. You freaking kidding me? Sure.
I'd say it's gonna be an emergency
Sure.
if you didn't get him out of his car because a cop's gonna break
I mean,
eventually.
hours putting paperwork against you, dude.
Yep.
Bro. with your childhood self. So disappointed in man you are. I mean, not just because you're fat, but just also because you're unrighteous. Unrighteous. And you didn't just talk to me like a man. You could have got everything squared away. You called back up, assaulted my friend, and kidnapped us both. For what? For what, dude? For what? You have my ID. You could have wrote me a citation and been on your way. What's your problem, bro? What's your problem?
Please stop talking.
And I would have corrected the paperwork on the back end. I wish you would have just wrote me a citation and under duress, and I could have just corrected the paperwork on the back end. But no, you didn't even give me opportunity to do that. You had to let me know why am I don't get it, bro. You know what it is? You fucked up, and now you have to try to hope that if you pretend like we're criminals, that maybe you won't get prosecuted. You're gonna get prosecuted, dude. If you were smart, you call your other officer and say that y'all need to apologize because let it flood. You realize that y'all didn't make mistakes. It's like other men.
Just remember, when we go through the federal complaint, this idiot's not even named.
How calm I was, right? I was peaceful. I was not a threat.
Caption.
Nobody, bro. I don't. No trouble. You're shaking.
That's when I'd punch him in the mouth.
You know, I would swear.
After a long day of work, y'all really would put that pussy and throw it to the cell. Are you serious? You didn't do anything wrong.
Not actually, but
Anything wrong.
yeah.
You need to learn what jurisdiction is. Jurists is people who have authority over you. Diction is like the dictionary. The words that.
Okay, you can't argue
You don't
jurisdiction when you're in the back of a cop car. Clearly, he has physical jurisdiction over you. Sorry.
He won. Okay, just go down
You're
gracefully.
handcuffed in the back of a cop car. He's got jurisdiction over your person.
He just doesn't stop. Like, at what point do you say, "Okay, I get it"?
You better not move my stuff.
Like, does he think he's gonna fight his way out of it? Like, the cop's gonna pull over and be like, "Oh, you're right. Here, let me let you out right here."
Oh yeah,
Call
you
you Uber?
win. You're right. I can see. I don't have jurisdiction here.
And to be no nothing. So just
Would you like a free bus ticket?
don't hurt me. All right.
The what? Oh yeah.
I'd be like, "Hold on, I gotta run to the bathroom real quick. I'll be right back." Just sit here for 4 hours.
Yeah.
And think about what you did.
Yes, Momosaurus Rex, absolutely.
Fine,
They
Doug, you step up.
Going to be fantastic in a courtroom.
I'm gonna walk right up here to the stage.
Hey, is it policy or can you take the handcuffs off? If I tell you as a man, I'm just not gonna.
As soon as we get into jail, I'll take them off.
Okay.
I love
Can you take my buddies off too?
Yeah, he'll get them off too. Just right around to this door, man.
Hey man,
Dude, they're in
do
so
me
much-
a solid.
They're in so much trouble.
After I just act
Right
like
here,
an
Cody.
asshole.
Right here,
They're in
Cody.
so much trouble.
I'm just gonna pray for him. I don't know.
I'm not signing nothing, dude. And I'm not saying nothing. I don't answer questions.
Getting right.
Hey, Cal. Long time.
Yeah, I just called him fat as fuck and weak and nervous for That's right.
But I want him to
yeah.
take my handcuffs
Correct.
off, which is against protocol, you know.
Yeah, I guess what we have the right to speak too, and we know how to say whatever we want.
Yay.
It's infuriating.
Oh, Lord.
So just in case you wanted to see what these beautiful, wonderful pieces of our society look like. Oh, thank you, Maria. The one on the left is Mr. Derek Phillips. The one in the middle is Mr. Cody Voss, who is no relation, just a friend. And the one on the right is Mama. So Mama was not arrested on the scene. She was arrested about a week later. And I actually wanted to point it out, but it was right when Judge Dad called. When they were in the bedroom fighting and the cop was trying to get him up, right after he got him off the floor,
Didn't she kick him?
No, she got between the cop and him and had her arm in between or something along those lines. And she pulled or something, pushed. That was that was the claim. But I believe the charges against both mom and son have been dropped because I can't find them anywhere. I can find the arrest, but I can't find any charges. I can find the friend's charges. So
Yeah.
that's
Well, shockingly, maybe entitlement actually works every now and again.
yeah. So Big Mouth son was actually charged with resisting arrest, search or transport, interfering with public duties, and evading arrest detention.
Okay.
So I'm thinking he probably, if he got evading and resisting, I'm thinking he probably did something else after they got him inside the jail. Evading arrest detention?
So evading would have been running into the home.
Oh, okay.
And resisting would have been breaking free of the detention. So you could have charged both of those in the same interaction.
Okay, that makes sense. So mom was just charged with interfering with public duties, and then the friend was charged with failure to identify, and then he also got tickets for taillight violation. Whoop-de-doo.
That would have been the end of it.
Yeah, and that was it. But people have gone absolutely crazy over this once they found out about it. And I think once the body cam video was released. So this is a petition from change.org for the mom, and the dad is the county commissioner, which we talked about. And they're calling for them to have resign both of their positions. They say they're a total embarrassment and have no respect for law enforcement officials, and that she was arrested after allegedly attempting to interfere with the arrest of her son. And she can be heard on multiple video clips of the incident using foul language directed at the deputies. And they've been known to make videos of themselves being pulled over for purposefully having a taillight out on their vehicle along with their son. I tried to find these, but I was not able to anywhere. Oh, maybe I should have read the whole thing.
Yeah,
that's
that was
their TikTok page. I saw this TikTok page and I saw them on it, but I didn't realize that was their TikTok page.
We might have to readdress this because I actually thought that Terry seemed relatively reasonable, at least from the body cam footage.
This TikTok page is like hardcore anti-cop, like, yeah. So people are not happy with them at all in that area, and they want them out of office. So one person commented, she got what she deserved when she interfered with her stupid kid getting arrested. She needed to, some of that got cut off. Why did that get cut off? You can't just obey the law because you work on the city, not obey the law because you work on the city council. And basically saying her son is just a privileged brat and knew his parents would save him. So they got arrested, and then the other son, who was not present in that clip, showed up at the council meeting.
Oh God, this clip.
So that guy right there, that's dad.
Sorry
that's
for
dad.
the spoiler alert.
So this is the city council meeting, county commission meeting.
Yeah, sorry for the spoiler on that one.
Why is there no volume?
I don't know. That would be on your end. Oh, he looks like a winner too. Love the man bun.
Oh, I might have to pull this up somewhere else. Okay, so he tried to comment on what was going on. And basically there was something on you have to comment on an agenda item. When you go to one of these meetings, they give you a comment card and they say, which agenda item do you want to comment on? And you have to write the number. Well, there was something in there to do with resurfacing a road or something along those lines. And so he said he wanted to talk about the roads, and they tried to make him stop. And he's like, Well, I'm telling you what happens on the roads in our county. You get pulled over and you get slandered, and basically saying that they've all this stuff in the newspaper about his family was defamation and all these things, his poor family, yada, yada, yada.
Meg, if you want to give me permission, I have the CBTV feed. It's only about 1 minute and 30 seconds. I can share that.
I just need to remove this, right? I don't need to give you permission.
Okay.
Do I?
Let's see. I think I do. So let's do that. And let's see. Let me know if the audio is coming through. Okay.
Thank you again for joining us.
Yeah, but I can't see it. Oh wait, this.
You have to approve it to go to the stream. Yeah.
It's so weird running 2 streams, but it's cool.
All
It's
right.
working.
I think this is the one that we're looking at.
Now I don't hear audio again.
I can hear it on my end.
That's so weird. Wait, here. Unmute the screen. Can you guys hear the audio? No sound. They can't hear the sound.
I can.
I heard the sound before you put it on the screen. When you put it on the screen, I couldn't hear it anymore.
All right. So what's the best way to do this then? Let's do.
Did you say add with audio?
I think I did.
Whatever it is.
Let me double check. Share. View and tab. So.
I know, what a name, right?
Here, authorize it to go to the screen.
Add to stream.
Okay. Let's see. If it doesn't work, we'll figure something out. Let me see. Let me know if this works. Anything? No.
Hit pause.
So let's see.
Oh, I thought maybe I could hit play. That doesn't work.
Here, you know what I'll do is in the private chat, I'll just send you a link to it and you can run it from your end.
Okay. Sorry, guys.
Yeah, we're still trying to figure out this whole simulcast thing. All right, let me know if you got that and if that works.
It is. You guys are amazing. I love you. You're the best.
I told you, I have the best chat in the industry.
They're half mine.
They're more than half yours at this point.
Where's the private chat?
On the right side.
Oh,
of your
there it
screen.
is. I've never used it before. You have to like know people to do private chat.
Yeah, because we can't send links in the public chat.
Okay, so I am going to share my screen and I'm going to show you the son is arrested, share tab with audio. Let me share pulse. I think it's this one. Is it this one?
Yep, that was the one that I was using. Now I can't hear it.
You can't hear it? You can?
I cannot. That is so weird. That's actually almost intentional. That has to be
No
intentional.
sound?
Nope. That has to be intentional. Let's see.
Oh, wait, I know.
You got it?
Yep. Like something's messed up because it's like still playing. Okay, there we go.
Play in your speakers, but none of ours. All right. Let's see if maybe there's another feed. I'll try to find.
Well, that one isn't really what he says there isn't really important. That's not the one you want to see. The one you want to see is this one, and I downloaded it earlier. So if
This is the moment Lance Phillips had to be forcibly removed from the Smith County Commissioner's courtroom after going limp. and refusing to comply with deputies' orders.
What's up with his hand?
Phillips returned to Commissioner's Court
Yeah, that
following an
was
attempt
red.
last week to speak.
Did you see that? Like, look at his hand when it flips over.
After going limp and
doesn't
refusing
it
to
look like the
comply with
circulation
deputies'
cut off?
orders. Phillips
No,
returned to Commissioner's Court following
looks
an
like
attempt
red.
last week to
Yeah.
speak on the recent arrest of his brother and the arrest of his mother for interfering. He was stopped due to his comments being unrelated to an agenda item as required.
It's not on the replats. You cannot speak.
Okay. All right.
Phillips returned this week to try it again and was even questioned by County Judge Neil Franklin before the meeting, resulting in this back and forth in which a deputy had to ask Phillips to lower his voice.
So,
Yay.
okay, that's the whole story.
Oh, no, it's not.
That was the whole story. And all of that happened. Oh gosh, when did that happen? Like March, I think?
February and March, yeah.
February or March.
If we can go back to the body cam, we can probably pull the date of the incidents. But I think that the date's going to appear on the complaint anyway, so
Yeah,
we can forge ahead.
it didn't really make the news outside of that local area. I mean, people in the local area were pissed. Like, seriously? But small town, whatever. But just this past, I guess, 2 weeks ago, maybe a little bit more, all of a sudden there are lawsuits filed. Miss Smith, even though the charges were dropped, now don't forget, the charges against mom were dropped and the charges against her son were dropped. And she still filed a lawsuit against the county and is it like 8 employees?
Yes, and I believe the state.
So what would you like to see? What would you like?
Do
you want to pull it up?
I'm trying to think. As a practical matter, we have the motion to dismiss on the kids' case. We don't on the mom's. So let's start with the mom. We'll go through her complaints. The kids is even stupider. So we'll just go downhill. So, would you like to read the opening paragraphs when we get to the law? We'll go from there.
Yeah, sure. So this was filed in the U.S. District Court for the Southern District of Texas, but it was moved to the Eastern District of Texas because it was filed in the wrong jurisdiction.
Yay, we're off to a great start. And by the way, this is a general form that you can download to file a federal lawsuit. This was not prepared by an attorney.
A complaint for violation of civil rights, non-prisoner complaints. There's a different form. If you're a prisoner and you have a complaint, this is for the non-prisoner complaint.
Correct, because the form includes a habeas in order to get in front of a judge.
And this is Karen K. Phillips versus the County of Smith, Philip Greeneed, Riley Rugg, Jonathan Peters, and Larry Smith. And they are all city employees, as we will see. So Karen Smith, we don't want to look at her stuff. The County of Smith and Philip Greeneed is a detective. And she had to add this one on because there weren't enough.
There were not enough boxes to check. So
boxes, thank you.
It's
It's getting late in the day, so I'm going to have trouble with words.
No worries.
So Larry Smith is the sheriff. He is actually the one who was dragging the son out. He was the one telling them to drag the son out of the council meeting. So she's suing him both individually and in his official capacity. That's important to note.
That's going to be an issue when it comes to qualified immunity.
Jonathan Peters is one of the deputies that was on scene and performed the arrest, and Riley Rugg was the other deputy that was there and performed the arrest. You may keep going.
By all means. I mean, if you want me to explain 1983, I can do so, but the facts, I think most people pretty much are familiar. So essentially, they're arguing that under 42 USC 1983, you can sue state or local officials for violating your civil rights under the Constitution. They have cited the First, Fourth, Fifth, Eighth, and Ninth Amendments in this particular allegation. Let's see how they actually go about trying to plead those properly. But that is the basis for jurisdiction, for federal jurisdiction, is that it's a claim brought under the federal constitution.
I'm not sure, Tiff, if she used her email, but she definitely did not leave her job. So, okay, right here.
But again, don't worry about doxing because it's a public document anyway.
That's true.
All right, so defendants acting in the official capacity for the County of Smith intentionally subjected plaintiffs. It's one plaintiff, so you can tell that they copy and pasted this bullshit. To mistreatment or to arrest, detention, search, seizure, dispossession, assessment, or lien. Again, you can tell this is a copy paste. That he knows is unlawful. They, because there are multiple defendants, again, copy paste bullshit.
So are they taking this out of like the law book that says this is what is illegal, and they're just copying and saying, "Hey, you did this"?
Yeah, that's why they're
verbatim.
That's why they're listing everything under the sun. It's basically a copy paste job. I've seen many filings, and in fairness, lawyers do a little bit of that too, but we try to actually, we'll copy and paste a general statement and then we'll tailor it to our specific case. They didn't bother to do that part.
No. Well, that's because the kid wrote it.
Well, this is the mother's claim, no? Maybe the kid did write it.
Cat. I believe he helped her with both of them. We'll see at the end. There'll be a non-lawyer statement.
Intentionally dire or impledes plaintiffs exercise their enjoyment of any right, privilege, power, or immunity, knowing his conduct is unlawful. Again, you have multiple defendants. They would be the appropriate pronoun. Defendants were wearing a Smith County uniform and badges, thank you, representing using authority and powers given to them by the County of Smith to deprive rights of plaintiffs. Okay, not the way that I would phrase that, but everything in bold, I think, is basically what they actually decided to write, as opposed to anything not in bold, which is just straight up copy paste. Under 18 U.S.C. 241, conspiracy against rights, it further makes it unlawful, which you did not claim in your actual cause of action, you idiot. This is what happens when you don't understand what the hell you're writing. Okay. And again, this is the clerk of the county. So I give absolutely, this is not even if the kid wrote it, this is the clerk of county that ultimately signs it. And clearly did not.
Should she have looked up somebody else's to copy it?
Persons to go in disguise on the highway or on the premises of another with intent to prevent, hinder his or her free exercise or enjoyment of any rights so secured. Section 242 of Title 18 makes it a crime for any person acting under any color of any law to willfully deprive a person of right or privilege protected by the Constitution and laws of the United States. Okay, so let's stop there for a second. This is their introductory paragraph. Here's the problem. One, it was a marked car. You admit that the taillight was out. It cannot be a conspiracy of rights because they were not on disguise, because you said literally in the sentence before that they were wearing the uniform and badges appropriate to their station. So you contradict yourself one sentence later. Everything is wrong with this premise of a lawsuit. So, all right, let's
don't dive too deep because we still have to read the motion to dismiss. I guess that's on the other one. Okay, where did it occur? When did it occur?
All right.
What happened? So this is what are the facts?
Go back up for a second.
What?
April 4th and March 28th. Didn't they say that it occurred in May? Scroll back up, please. March 28th and April 4th. Remember those dates.
Mm-hmm.
Look at what their actual statement was. Keep going up. Maybe I'm wrong about this. Because there was a date in May that they said was the actual incident that caused the action. All right, never mind. Let's go back down. I'm pretty
I
sure
don't
it's in
remember
there
seeing
somewhere,
a
but we don't
date.
have to go find it.
That might be on the other one. So she
might
was
be.
arrested. So the first date is when it happened at the house, the 328.
Yeah.
And then the 4/4 is
That's when she was arrested. All right. Facts underlying your claim, Section C. Under color of law, Burnett wrote an arrest warrant affidavit with many false statements with the intent of getting me arrested and confiscate, God almighty, my recording of an incident which occurred in my driveway. You can't even spell
So did
your
you,
word right?
I'm not sure if I got that on the video or not, but they went up to her in the driveway and said, hey, your son wants us to take your recording of this as evidence.
Yes.
Her son specifically asked for it, and she said no.
So this would not have been the March date. This would have been referring to the April date when the arrest warrant.
Both?
No, it would have been the arrest warrant that was requesting the video documentation.
Right, but that's where it started. That's how the
So that
cops
would-
found out about.
Right. What I'm saying is that would have been referring to the April date. But again, she doesn't know how to put an S in the word confiscate.
She seriously put. Sorry.
She literally said confiscate.
No. When Googled.
Phillips swore to this affidavit in a court of law, which was falsifying a government document. When Googled, oh dear God, states, often simply referred to as false and misleading statements, makes it a felony knowingly and willfully to falsify or conceal material facts, make oral statements to officials, material false and misleading to an official, federal government, an investigation or official proceeding.
Yeah, we find like
these were all fucking state officials. Sorry for the cursing, but
not that hard to find a copy of the U.S. code that you have to put.
But this isn't a federal offense. These are all state officials. 18 USC doesn't apply here. Okay.
Okay, so what is 18 USC? Oh.
18 USC is the federal criminal code. It's Title 18, which is the federal criminal code.
So do you want to explain why it doesn't apply here?
Because these are state officials.
And so that would only apply if they were federal officials. So there's a equivalent state law that she should be citing.
Presumably. And in most states, there is a similar state law. But yeah, federal law does not apply to this incident because there were no federal agents. There was no diversity of jurisdiction. This all occurred within Smith County to Smith County residents by Smith County sheriffs. So there is no federal component here. Statements which were false were: 1. Phillips swore that I, along with my son, were standing in the carport area of the residence. The body-worn camera of Riley Rugg and Jonathan Peters show we have a 3-car garage attached to my home. My son Derek and I were standing in my home talking with Riley and Jonathan when they ran at my son, chased him further into the home, and arrested him. He was not a suspect in a crime, and there were no exigent circumstances. When Googled, exigent circumstances are Jesus Christ.
All right, that's 2 Googles. Everybody take a shot.
Yeah, all right. You gotta take over for a little bit. I'm gonna have an aneurysm.
Yeah. Situations that require immediate action to prevent harm, damage, escape, or destruction of evidence, and that justify a warrantless entry, search, or seizure by police when a warrant would normally be required. B.
Yes.
Compare knock and announce rule. No knock search warrant. This has nothing to do with it. An emergency situation requiring swift action to prevent imminent danger to life or serious damage to property, or to forestall the imminent escape of a suspect or destruction of evidence.
Wait,
right
hang on.
There.
Reread that last clause.
or to forestall the imminent escape of a suspect or destruction of evidence.
Bingo.
Done. In the criminal procedure context, exigent circumstance means the following: an emergency situation requiring swift action to prevent imminent danger to life or serious damage to property, or to forestall the imminent, why are we repeating this again? Or destruction of evidence. This was not a criminal procedure. A criminal procedure is the laws and rules that govern the steps taken and methods used in bringing and conducting a criminal action. Speech is not a crime.
Yes, but fleeing and eluding a law enforcement officer that has to go into detention is.
Exactly. That was when it went from.
That's when it went from a simple traffic stop to a potential felony.
Jesus. Facts underlying claims continued. A situation or circumstance that requires immediate action. Oh,
By the way,
God.
just
Origin.
the fact that they started a new heading and continued the subheading with E drives me insane. It's bad draftsmanship.
Can you put continued in a heading?
Generally speaking, if you're filing a complaint, you will say the facts, plaintiff alleges the facts above as if incorporated here below. And you'll use it just as the first paragraph of your new section. It's a common way of doing it, but you don't just continue your lettering when you create a new heading.
I feel like she wrote continued at the bottom of the page with the arrow, like turn it over to the other side.
Yeah.
Origin, 1400 to 1450. Latin. What is exigent circumstances in the U.S.? The concept of exigent circumstances applies to the application of the Fourth Amendment's right to freedom from unreasonable search and seizures. F. Does she actually put footnotes in here?
Wait, no, she didn't create a new paragraph. She just put F without hitting enter.
And she didn't even make it little.
Oh my God.
Hold on. Nope, nothing at the bottom of the page. All right.
Get through.
Let's just keep going. Refer to situations that demands unusual or immediate action, and this allows people to circumvent usual procedures. In other words, emergency conditions. The circumstances are such that it would cause a reasonable person to believe that prompt action is necessary to prevent physical harm to the officers. It is ludicrous. But the actions of our family friend, Cody Voss, who was being arrested for defective tail lamps, were written about on my arrest warrant affidavit.
Yes, that was the inciting incident.
Wait, hold on. That sentence doesn't even make sense. It is ludicrous, but the actions, like, that's not even a coherent sentence.
There should be a comma there, and maybe it would make sense, but yeah.
Detective Phillips Greened wrote these statements, stood in front of a district judge, duly sworn an oath to say his words were a truthful account of the details of March 8th, 2023. Karen K. Phillips
Once again, didn't hit enter, just start another letter. I'm sorry, this is driving me nuts in my little, like, draft.
At least she's using periods, okay? So just stop. It's not one big run-on sentence.
It is, but...
Give her a little credit. Did then and there commit the offense of interference with public duties, Section 38.15b of the Texas Penal Code, a Class B misdemeanor, in that she then and there, while Deputy Peters hereafter styled the complaint, a peace officer was performing a duty or exercising authority imposed or granted by law, namely detaining Derek Phillips. 2. The sworn to affidavit by Detective Philip Greeneed? I feel like I'm butchering his name. Philip G. further states, with criminal negligence, interrupt, disrupt, impede, or interfere with the complainant by grabbing at Deputy Rugg as he was in pursuit of a suspect and pushing Deputy Peters away from Derek Phillips, who was being arrested. 3. Affidavits are to be written in chronological order and statements written. Really? She's going to critique someone else's writing? Are you shitting me? Affidavits are to be written in chronological order and statements written by Detective Philip G. are not. 4. Detective Philip G. wrote on the arrest warrant affidavit. Philip G. reviewed the unit body cam footage and reports completed by Deputy Peters and Deputy Rugg, and then swore before the court his statements were true. However, his statements are not true. Period. Philip G. quoted the words of Deputy Peters by writing.
We all watched the body cam from at least one perspective, and so far his affidavit seems fairly accurate to me.
Yes.
I don't know if you disagree, but I think that from the video that we watched, the affidavit seems fairly accurate.
Look at the puppies. Take a deep breath. Look at the puppies. Take a deep breath. By the way, my backdrop is Morocco. Nobody knew that because it kind of looks like a beach sunset, but this is actually the desert. You know, it was a little ode to the Moors. I had to really think about that one. I was like, what the hell do I use as a backdrop here?
Well played.
Okay, according to Deputy Peters' report, however, as a detective, his job is to determine on his own, after thorough review of all evidence, not merely quote from the statements by the deputies. Had Detective Philip G. actually viewed the videos from body-worn cameras and the unit cameras, the words on his arrest warrant affidavit would have been accurate. Detective Philip G. wrote, according to Peters' report, the driver of the white pickup exited the vehicle and began yelling. Okay, he did. Detective Philip G. wrote, Derek Phillips continued to retrieve items from his pickup truck and walk around Deputy Peters. Words matter. Derek Phillips was not walking around Jonathan Peters. That's what we're going to argue about?
Really? Okay.
He got a dictionary, slammed it on the back of the car, and was all over the place. Okay. Detective Philip G. wrote, Deputy Rugg began speaking with Derek Phillips and Karen Phillips, who were standing in the carport area of the residence. If Detective Philip G. viewed any footage, he would not written the carport since we were standing in our 3-car garage.
He's using carport as a driveway. It's literally a synonymous phrase. Jesus Christ.
Words matter. Detective Philip G. wrote, Deputy Rugg instructed Derek Phillips multiple times that he was impeding their investigation. These words were never spoken. Detective wrote, as Deputy Rugg pursued Derek Phillips, Karen Phillips reached her arm toward Deputy Rugg to impede his pursuit of Derek Phillips. Also in the sworn arrest warrant affidavit, this same scene was described as Karen Phillips grabbing at Deputy Rugg.
Okay, hang on. Pause for 1 second, because this is bullshit. They were not sitting in their garage. They were sitting in the driveway. We have the video. That's what he meant by
standing right
carport.
outside. Yeah.
They were standing in the driveway. That's what he meant by carport. They were all in the damn driveway. It's on video. You were not sitting in your garage, which actually would have a higher level of security on Fourth Amendment searches. But we don't have that. You're making it up.
They were standing right in the opening, weren't they?
They were standing next to the damn cars.
So what does it matter, if the door closes or not? Is it open or is it closed? Is it a garage or is it a carport? Or is it a
Well, again, so
veranda?
they're using carport interchangeably with driveway, or what we would call a driveway.
People use from different parts of the country call things different.
Right. They were not sitting in the actual garage.
Some words just don't freaking matter. Okay?
She was literally standing in the driveway in plain view of the road.
The bottom line is, it doesn't matter where they were standing.
No, it doesn't particularly.
Because they were in the process of trying to...
All right, I'm going to shut up, otherwise we're never going to get through this.
Yeah, and he took off, so... She's very proud of her 3-car garage, okay? Just let the woman have her freaking 3-car garage.
Lovely. Congratulations. I'm glad the taxpayers covered that. Because both
deputies,
of you are getting your money from fucking taxpayer dollars. Sorry, from taxpayer dollars.
Deep breath. Let it out. As deputies were apprehending Derek Phillips in the bedroom of the residence, Karen Phillips began approaching deputies, screaming, "Get out of my house." Words matter. We were in a tight area of my bedroom, and I did yell, "Get out of my house." If I never asked, then they would believe they had permission to be there.
That's not how that works.
They gave a shit.
That's not how any of that works.
constantly screaming as this statement would make someone not viewing the video to believe. Detective, like the people who are making the decisions aren't going to view the video. Like Detective G wrote, Karen Phillips reached her arm between Deputy Peters, pushing him away from Derek Phillips as he was escorted out of the residence. This is lousy detective work.
It's on freaking body cam.
The video clearly shows me using my pointer finger on the shoulder of Jonathan Peters to poke him 4 times. Not 1, not 2, not 3, not 5, but 4. Numbers matter.
That's more foreshadowing.
What the fuck? 4 times. 4 times.
It's not 3 times shadowing. It's not 5 times shadowing. It's foreshadowing.
It's 4 times. As I'm saying, he can't see. He needs his glasses. Side note, my son can't focus on items inches away from his face without his glasses. My main concern during this event was ensuring my son had his glasses. Detective G wrote, Karen Phillips continued to inject herself into the investigation.
Yes.
The incident began in my driveway, continued into my bedroom with 2 people being arrested for videotaping and yelling at a peace officer when the issue was defective tail lamps. Nothing in this scenario made sense then, nor does it now. That's the only true thing I have read so far. I'm guessing Detective G thought I should have returned to the living room to continue reading my book. Probably would have helped. Or, talk some sense into your children. Either or, take your pick. I wasn't injecting myself into their investigation. I was videoing it so they couldn't lie about what happened. But even with multiple recordings, these people falsely reenacted the story on paper. I believe that false statement written on the arrest warrant affidavit, bold, by Detective G, and sworn to in a court of law, bold again, were misleading and extremely deceitful, and their main purpose was to persuade the magistrate I needed to be arrested. When in fact, my interaction with Jonathan Peters and Riley Rugg on March 28th, 2023 was based on the location of the event, my driveway and my bedroom. And once my son lost his glasses in the tussle with 2 peace officers was to ensure my son could have his glasses before being led away. My intent was not to stop the arrest of my son. Never once made any statements indicating my intent was to keep my son from being arrested. I'm pretty sure she did. There was a lot of, why are you doing this? This is ridiculous. Just let him go.
I believe she did inject herself into the investigation in an effort to prevent the arrest of her son. I think we all watched that together.
Yeah, you can't arrest my son. Screaming is not a crime. Cussing is not a crime.
Nope.
Having defective tail lamps is not a crime. Calling someone an idiot is not a crime. Crime is defined as illegal activities, an action or activity that, although not illegal, is considered to be evil, shameful, or wrong.
I don't know where you got that definition from. Can we see her citation?
Yeah, what the hell?
She appears to have a citation. Or
are there citations here?
No, I think that's actually just another paragraph marker. So that's not actually related to anything.
So crimes are not illegal. That's a new one for me.
Uh-huh.
They're just evil, shameful, and wrong.
Yeah. No.
But tampering with a governmental record is prohibited and is a crime.
That is
But it's not illegal because crimes are not illegal.
Wait, so are statutory crimes not crimes unless you're using them against people that are not you?
That's a whole nother rabbit hole. I don't even know.
Okay. Yeah, it was a little bit misread. She's saying that crime is defined as specifically illegal activities or an action or activity that, although not explicitly illegal, is considered to be evil, shameful, or whatever. That's kind of the common law concept of crime, as opposed to it being a statutory infraction. We got rid of that a long time ago in terms of actual criminal statutes. But
I was going to say, I've never heard the although not illegal part of it.
There are plenty of things that are not illegal that could still be a tort, but it can't be a crime unless it's specifically prohibited by statute. And again, to those who don't know,
I guess I don't really associate crimes with torts?
Lawyers do. So crimes are what can actually get your freedom taken from you. Torts are what can have money damages taken from you. We decided that common law crimes don't exist anymore, and it has to actually be statutorily imposed. Otherwise, it's not a criminal statute. Unless there's a criminal statute that applies to the conduct, we can't take away your freedom. But you could still potentially, under common law, still have a tort issue. I don't know if that makes sense. If I can explain it better, let me know.
Yeah, no, I got it. I don't know if everybody else does. Yeah, they wanted her out because they thought she was like kind of a POS. But at this point, I think they could use this as proof to get her fired. Like, incompetence is the thing. So basically, she's going through talking about he falsified the arrest affidavit because he put all these statements in there that were untrue because they didn't happen in her world. The carport and my dog has not moved in a very long time. Ziggy. Okay, there's an ear. Sorry, just making sure. I mean, I did drug him earlier because there was a storm, but geez, the thing really hasn't moved. Okay. The number of hypothetical statements written by Detective G is overwhelming. Numerous statements sworn to in a court of law and attached to Karen Phillips' arrest warrant affidavit were misleading. Did this detective wake up on April 4th, 2023 and made a decision to begin stretching the truth on the affidavit he wrote on my case? Or has this way making misleading statements been a lifestyle this detective has followed for many years? God, her grammar sucks.
Oh, dear God. This is your freaking county clerk, Smith, Texas. Anyone who happens to be in Smith, Texas, if you're within the sound of my voice, my God, vote this woman out. This is the person that's responsible for all of your freaking property records.
An affidavit is a written statement of facts confirmed by oath or affirmation for use as evidence in a court of law, written in chronological order, and most importantly, it is factual. Being truthful to a court is vital, whether communication via an affidavit or in person. It is the detective's core job duty to investigate and find truth, not to distort truth. I demand all cases with the name Detective Philip G attached be reopened and investigated once again to determine whether you can't do that in the middle of a complaint. Can you? Wouldn't that be like a separate motion?
No, it would probably be in your addamnum clause or your prayer for relief.
Okay.
You can put it in your argument if you repeat it in the addamnum, but I actually don't, if I recall correctly, I don't think she does.
She wants every case that he's worked on opened and reinvestigated.
Yeah, the answer is going to be no.
Hmm?
The answer is going to be no.
Yeah, that's ridiculous because he didn't do anything wrong to begin with.
No, and you haven't proven it. You can demand whatever you would like, and the court can say, yeah, no.
Whether untruths were written there as well. I request the magistrate to whom this statement is presented to execute an order determining probable cause for an arrest warrant and continued detention of Jonathan Peters and Riley Rugg and Detective Philip G on appropriate charges of falsifying governmental records with intent to defraud
not how
or
anything
harm
works. Oh my
another.
God. Oh my God. Sorry, I need to.
In charges of criminal coercion. Coercion defined is. Oh, she doesn't say whether she Googled this one, though. I wonder if it came from Google. To expose a person to hatred, contempt, or ridicule. John's screaming at a pillow in case anybody wondered. Hold on. I have the solution for this.
Holy crap! How stupid are the people in Smith County, Texas, who have elected you and your goddamn husband to office in that county? All right.
Don't break things. Don't break things.
I'm back. Sorry.
We were having a box fort moment. Okay. When things get bad, we're just gonna box fort it. Box fort it. Everything's good in a box fort.
I'm good.
Okay. Coercion, defined as to expose a person to hatred, contempt, or ridicule, to harm the credit of business repute of any person, or to take or withhold action as a public servant. To accuse anyone of criminal offense. I request the magistrate to whom this statement is presented to execute the order of determining probable cause for an arrest warrant and continued detention of Jonathan Peters and Riley Rugg on appropriate charges of burglary of a habitation, aggravated assault with a deadly weapon, impede normal breathing, aggravated kidnapping with a deadly weapon, false imprisonment, and criminal trespass, and setting no bail, if any. No bail, if any. Furthermore, my First Amendment right was violated.
I'm glad you're reading this and not reading.
The right of the people to petition the government for a redress of grievances. When I attempted to speak with Jonathan Peters in my driveway at my home about what was happening, I was charged with interfering. Gaynor v. Roberts? You may verbally challenge the officer's action and ask for his ID.
That's not relevant to your statement, you idiot.
And I think you're supposed to wait until he's done, like, chasing the guy down to handcuff him.
Okay.
Or you try and ask what's going on. My Fourth Amendment right was violated. This amendment states the right of the people to be secure in their persons, house, papers, and effects against unreasonable searches and seizures.
Will not be violated. No warrants shall issue except. I'm familiar with the Fourth Amendment.
A probable cause upon oath or affirmation, in particular describing place. My Alpine green iPhone 13 Pro with a black case.
I love how she's very specific about that.
Was a Mother's Day gift in 2022 and valued at over $1,000. The warrant for my phone stated a dark in color phone, model number unavailable, serial number unavailable, phone number unavailable, in the possession of Karen Phillips. Stealing my phone violated my right to be secure in my effects against unreasonable searches and seizures. They give the shit back. Dear God. The police car had a camera recording the events, and both Riley Rugg and Jonathan Peters had body-worn cameras recording. As the additional officers and supervisor arrived on scene, they also had body-worn cameras recording. My Fourth Amendment right was also violated when Riley Rugg and Jonathan Peters entered my home on the night of March 28th, 2023, without a warrant. My son, Derek Phillips, and I were standing inside my garage talking with Riley Rugg, who never said, "Stop, you are under arrest."
There's no magic words. It doesn't work that way.
Neither my son or I were told you're being detained. Like, what?
She's basically
I have never seen someone standing face to face having a conversation with a cop, take off running, and not get tackled.
Right.
Ever. If you take off running, there's a reason you took off running.
But here's the thing.
A cop's not going to let you just run away.
He's operating as though that you have to operate by magic words, and it doesn't work that way. No. Situational awareness and the training of the police, and this is also to answer Trenton, who he and I disagree on a number of things, but it is absolutely appropriate when somebody is currently being detained and they flee into a residence for the police to follow. Period. That is an exigent circumstance, 110% every single time. Because I don't know why you're fleeing me. Yeah. Maybe you're trying to destroy evidence. Maybe you have shit on your person that you don't want me to search you for because you're under detention. You think that you might be under arrest at some point and might be searched. I have no idea. But that is absolutely squarely within exigent circumstances.
Yeah, and I think I posted the doctrine earlier, the hot pursuit doctrine. Yeah. I actually called it, I called my wonderful friend, Detective Lockhart, who I'm sure is not still watching the stream at this point in time because, you know, he's a busy man and can't listen to talk for this long. But I asked him what it was that gives him permission to, you know, do that. And he said, hot pursuit. So
yep.
That's how the cops view it, just to give you another look at it. But it all falls under the same thing. Like, they're not going to stop when you run into a house and say, oh, well, yeah, I mean, we've all seen police chases, like on TV, where the helicopter's flying over and you see the guy run into a house. Like, they're just gonna go after him. They're not gonna just let him.
Again, it's not like, you know,
home base.
Exactly.
It doesn't work that way.
No, it doesn't. It doesn't stop. Like, they still have the ability to conduct their traffic stop just because you happen to get one.
I don't think Zen pet videos work on John.
Not particularly.
Okay.
All right, let's keep going. We still got a lot to get through.
I know. I continued videoing as these two men chased my son further into my house, into a house owned by Terry and Karen Phillips. Like, couldn't you just say me? Violating our Fourth Amendment right. In fact, the Supreme Court has stated.
You referred to herself by me and previously in the document. Sorry, this is the draftsman in me.
I know, it's fine. The Supreme Court has stated that the very core of the Fourth Amendment's guarantee is the right of a person to retreat into his or her home and there be free from unreasonable governmental intrusion.
True.
Either is unreasonable. This is reasonable. It's considered the Castle Doctrine. When Jonathan Peters and Riley Rugg entered our home, it was without a warrant, and they were not pursuing a felon. They were not pursuing someone suspected of committing a crime. Untrue.
It's state law. It is not federal law, so it's not appropriate in the federal complaints, but okay.
Yeah. I mean, a lot of states have adopted it, so it's not just single states.
It doesn't. I mean, under Erie, they probably apply it anyway, but okay.
They were pursuing someone who had committed a crime. He had already decided to charge him with interference because, like, within 30 seconds after getting out of his cruiser, he was interfering with what was going on. Like,
correct.
He was getting the dictionary out of his car. He was being belligerent. So, yeah,
correct.
He had committed a crime a long time before he decided to run. Naval forces, militia, yada, yada. Jesus. So the only possible reason for them to be holding me or my property was Sheriff Larry Smith and the deputies acting under his authority were attempting to say that I was a public danger since I was arrested without a grand jury for interfering by asking no less than 25 times what is going on. And my son needs his glasses. My Eighth Amendment right was violated. Dear God, paragraphs.
Real quick, Meg. I really want to ask about this one because watching the video again, did you hear her say my son needs his glasses once in the body cam?
I did not.
Okay, so I don't know where the hell she's getting that from.
There was conversation about the phone.
Yes.
But I don't remember hearing anything
about
glasses.
We're bringing up the glasses.
I mean, I did see the picture, and it does look like he's got some hardcore Coke bottles, but...
And that's fine. Like, I don't have a problem with that, but all I'm saying is I don't recall her actually saying that. And if I can, real quick, J. Michael RN, thank you so much for the 20 gifted memberships. I really appreciate it. Thank you.
Awesome. Yeah, I can't see your stuff. Damn. Can you put stuff up on the screen?
I cannot. You have full control over that. So I keep flipping back and forth from my feed to the StreamYard.
Interesting. I'm trying to get most of them, but...
No, it's all good. I appreciate it. You've been doing great. Anyway, yeah, I don't remember her talking about the glasses at all in the body cam footage. That's all I was going to bring up.
NC says that she did ask at least once, but even so, one time, okay. Like,
it's not 25 times.
And I heard her say what is going on like once or twice, but not over and over and over again.
Yeah. All right, when we're at the end of this paragraph, I'll pick up. I know it's a lot to read.
I'm fine. But if I'm not reading good.
No, you're good.
Trust me, I will get a million.
I'm just offering you a reprieve.
A million comments telling me I need to go to complaint reading school to learn how to speak correctly.
Nah, you're good.
People love to tell me how to be.
You're doing a fantastic job. I have no complaints whatsoever.
Yeah, I don't give a shit what they say anyways. The sheriff contacted me to notify me there was a warrant for my arrest and 2 officers were coming up to get me. Oh, she was at work. He agreed I could turn myself in to the security guards on the first floor who were positioned at the front door. My office is on the third floor of the courthouse annex building. 3 officers got off the elevator as my husband, county commissioner, and I, county clerk, were headed to the first floor. As an elected official and being arrested was humiliating, and my personal property was stolen as evidence since I videoed the incident in my driveway. All this occurred because I was asserting my First Amendment right to speak to the officers at my home. My Ninth Amendment right was violated. This amendment states, we know what it states. My rights were denied as listed above. Additionally, my rights and the rights of my son, Derek Phillips, and his friend, Cody Voss, were regarded as having little worth. Witnesses to the event involving Peters and Rugg violating our civil rights are Phillips and Voss. Okay.
Yay. Injuries. Here we are. If you have any injury or require treatment, please state so. Amendments. The paragraph states, the same information is confidential without the requirement to take affirmative action for an increasing number of officials under section 552, colon 117 of the code. These include elected public officers. It continues, the legislature has identified as needing protection from public access. It should be access, idiot, to their personal information, including information, which she still can't spell that word either, information, that might reveal whether the person has family members. Except as discussed below, the information may not be released, nor may this information be released when it relates to a peace officer, reserve law enforcement officer, commissioned deputy, game warden without a comma, or correctional officer if the person was killed in the line of duty. Side note, oh Lord, on July 29, 2022, a sheriff's officer was killed in the line of duty.
Can you put side note? Is that like legit?
No.
Because that sounds like something I would write in like
that would
an
have
email. Side note.
If I put that into when I was in law school, if I put that into one of my legal writing classes, I would probably be expelled.
Okay. It's been a long time since
that
I
would be
my law classes, so things might have changed since
that should be a footnote.
The dinosaurs were walking.
Yeah, that should be a footnote, if anything. And I don't care about this particularly.
Okay.
Body being launched from the patrol unit, second officer on scene having retrieved the officer from under the patrol call, went on to say he left behind children, information on family members, and a revised statute is prohibited from being released. Okay, that's utterly irrelevant. I am the current Smith County Clerk, an elected public officer who performs governmental functions, so this statute specifically applies to my sensitive data, which includes my name, my home address, my phone number. No, none of that is true. My date of birth, maybe. And whether I have family members should be, okay, you really should have a, okay. Should be kept confidential.
Yes, but her kid was screaming out, do you know who my parents are?
He might have actually divulged that information during the course of the stop.
It was either him or the
or it might have been, yeah.
One of them said who they were.
Yeah, so not so much. In the TAC Public Information Act booklet dated 2021 on page 39, the first paragraph states, personal safety. Information relating to an employee or officer that, under circumstances, would subject the person to substantial threat of physical harm is accepted from the disclosure under the Act, Texas Government Code, Section 552.151. I believe that this is their version of the Freedom of Information Act.
Mm-hmm.
So essentially, they don't necessarily have to provide identifying information, but they do have to give a name and salary. In addition,
I think every state has that, like some kind of protection for governmental employees.
Well, I mean, I'll give you federal law protects attorneys from protests outside of their personal homes that is designed to influence their behavior in front of courts. So, there are protections for people who are part of the governmental apparatus, but she's reading that a little broadly, in my opinion. In addition, the Supreme Court has held that common law protects information of its disclosure from its disclosure, you idiot, would create a substantial threat of that would create, dear God, you can't write. Please, please, Texas, throw this person out of office. A substantial threat of physical harm to a person. On March 29th, we requested a copy of the body-worn camera recordings of the multiple officers on the scene and were told you cannot obtain a copy of these recordings after it after it goes to court.
That's standard. So I can tell you,
I don't think that's a legitimate quotation because I don't think that they would have written it that way. That's somebody writing a nonsense sentence.
I do a lot with missing persons, cold cases, things like that. You cannot get a piece of paper related to a case until that case is closed.
If you are a party to a civil action, you can request a subpoena that would require them to turn it over, regardless of whether it's an active investigation.
That's true. I guess I wasn't thinking about the fact that she would be a party to this.
Yeah.
But she has to actually be charged. So technically she's not a party until charges are filed.
Well, she's a party in the civil action. Because she's the one bringing the civil action.
Right, but she's talking about, she contacted them the day after the incident.
No, at that time, not necessarily, but I think under the
there's no action.
The federal court would grant a subpoena for those records.
At that point, it would be the two boys that were parties to it. Because she had no charges against her at that point. Well,
but because she's bringing the civil action, it would actually honestly.
But we're talking next day after the incident.
No, day after. The answer is no. But if we wanted to request it after filing the civil suit, that would probably be up to the court's discretion, and they would probably still say no. But there's at least a shot.
Wait till we get to the other one. There's 3 documents.
I know, Jesus. All right, I'm going to keep trying to plow through this.
Okay.
Texas Administrative Code, fee for obtaining copy of body-worn camera. This section provides, I don't care. We can move on. This is just talking about the actual practical procedure for obtaining body-worn camera footage. I issued a request to investigate the sender to issue charges on them by contacting the Smith County Information Technology Department, Smith County Sheriff's Department, and the Tyler, Texas Police Department, but no one could identify who sent this email to my work address. This would be due to 2 million viewers having my personal sensitive data. I've received threatening calls. One particular email I received stated blah, blah, blah. Okay, I don't care. So,
but go up some. I missed a little bit of it. She's saying that it's the public information officer's job to treat all requests for information uniformly without regard to the position or occupation of the requester or the status of the individual. And due to millions of viewers on YouTube seeing my job title, full name, full address, my personal phone number, and the names and birth date of my child and my husband, due to 2 million viewers having my personal sensitive data, I've received threatening calls and threatening emails at my office.
You don't have, and this has been an argument that's been going on YouTube for a while now when it comes to doxing. You don't have a presumption of privacy when it comes to, particularly when you're a government employee, job title, name, personal number, maybe. Children, probably not. Husband, maybe. Your address, I mean, look. I'm old enough where I remember the white pages. You didn't have a presumption of privacy on your personal address. If I had your name, I could find out where you lived. So that's kind of it's a BS argument. If I have your name, I can find out more than you would like to know about you. One particular email received, email stated, you need to be violated and your son needs to be done away with. I issued a request to investigate the sender to issue charges on them by contacting the IT department, Sheriff's Department, Tyler, Texas Police, whatever. Okay, and?
Yeah, VPN.
I mean, guess what? Meg, I've received comments like that in the past. Have you not?
No?
Okay, well, I have. That didn't mean that I decided to try and start a federal lawsuit.
Please don't say mean things like that to me. I don't know if I can handle all that.
Please don't. I am much thicker skinned. I promise you. If you have anything mean to say, if you do not particularly like today's stream, please direct it all at me.
I cried when they told me I talked funny. Okay, so people are calling our house at all hours of the day and night, mutter hateful statements, hang up. People full of hate have been driving by our home after midnight, laying on their horn for 5 minutes or more, which is so frightening because people who are full of hate know our address because of this unredacted video provided to the media by Sheriff Larry Smith. For this, I have to say, for every cause, there is a catalyst.
Yes.
And that catalyst is your asshole son.
This
So
is
maybe fix that problem.
This is a Streisand effect issue because
Oh my God, totally.
If they did not decide to file these complaints, we would not be having this conversation.
No, as soon as they filed these complaints, that's when Law and Crime picked this up and
None of
aired
us
the
would
body
ever
cam
pick it
footage.
up. It
So
would have been
she's
some
talking-
rural county east of Dallas or east of Houston, or no, it was east of Dallas that nobody cared about.
And
But once you do this, congratulations, you threw your hat into the arena. This is the whole point of the idea of a special purposes public figure. When you subject yourself to public review by, for instance, filing a federal lawsuit that anyone can pull, then you reap the consequences. It's just the nature of the game.
Absolutely. And she said millions of views, but it was just the local area.
Yes.
This lawsuit triggered Law and Crime picking this up.
Absolutely. And again, if they had never filed this lawsuit, it probably would have just died.
Thank you. I love your name. Such a cool name. Yeah, it probably would have, but now she's special and she's gonna lose her job over it. Additionally, Larry Smith has given multiple interviews on local TV stations stating lies. He stated they said they were sovereign citizens. He knows this statement is a complete lie, but I believe he made this statement to incite hatred towards me and my husband, Terry Phillips, the county commissioner. The false statements made against my husband, the county commissioner, and myself, like how many times is she going to call him the county commissioner? Jesus. Made on the nightly news by Sheriff Larry Smith have caused unease within the county as people take sides to support either the sheriff or my family. As elected officials, my husband routinely attends the monthly peace officers luncheon. And on occasion, I attend as well. We have numerous friends in law enforcement. You also have a TikTok that is very anti-law enforcement. This situation has caused extreme mental stress in my personal life and my church family, with close friends who have family members in law enforcement in my life and dealing with other department heads and elected officials. My work requires me to daily interact with security guards, peace officers, and other county officials who have an obligation to defend the sheriff. No, they're doing it because it's the right thing to do, and you're a jackass. Sorry.
Their job is also to defend you. Just, throwing that out there.
They don't stop by and talk to her anymore. They ignore her greetings. Her life is completely changed. She stopped by a drive-through restaurant and they were mean to her. She broke down crying, realizing people have acted normal around me, have not acted normal since this began. Oh, Karen.
You poor baby.
Bless your heart.
Congratulations. When you piss off an entire community, maybe they're not going to be as warm to you anymore.
I think she's pissed off pretty much everyone that's watched it.
Yeah.
And now she's back to copy paste.
Yeah, it's all copy paste.
Sadness.
Hang on, I just want to say, suing release sensitive data prohibited by law, which cause mental anguish, anxiety, night terrors, depression, stress in most every relationship, fear, sadness and crying, anger, and headaches. Oh my God, this is the flimsiest. remember, she's not arguing under the tort of like negligent emotional distress. She's arguing under civil rights violations.
Well, I just want to say that reading this shit has triggered my MS, which has caused all those things.
So you should sue her.
Just need to sue her.
Yeah.
I might need to start drafting that up because
I think I've literally lost like IQ points as a result of having read her complaint.
she got night peepees. Okay.
We're almost done with this.
$10 million. I just can't. I can't say it seriously.
$10 million. Jesus Christ.
$10 million because they wanted to take your phone.
I swear to God, if we cut her up and sold her organs on the black market, we wouldn't get $10 million for them.
And they were mean to her at the drive-thru. Well, maybe you didn't need that second Big Mac.
$10 million. I need one of your cats to sit on my lap so I can pet it.
Sorry, they're all broken. You can't see them, but she's like half over here, half on the bed.
Oh,
Lord, bed earlier, and I gave them hemp treats. They're out of it.
Let's get to the signature page to point out that this was all pro se and there was no lawyer that would touch this.
Signature of plaintiff, Karen Phillips. 4 attorneys.
4 attorneys. Nobody.
None.
Nobody's touching this case.
None. Oh, they didn't even have like the lawyer for anything.
Nope. Well, it was a complaint, so none of the other lawyers have to sign it. The defendants only have to answer.
Nice.
Or move to dismiss, which I imagine they will. So there we go.
Okay.
We haven't even got to the freaking kids in the motion to dismiss yet. Jesus. All right, we got to speed run this.
Okay, so what do you want next?
Let's do the kids because the motion to dismiss is in response to the kids, right?
You want the motion to dismiss or you want the kid's actual complaint?
Let's do the kids. I'll speed run the complaint because a lot of it's the same crap.
Okay. Yeah, it's pretty easy to.
So we'll speed run that and then we'll do the motion to dismiss and I'll explain how actual lawyers respond to stupidity. I mean, one moment. If you want to get started, I just have to use the restroom real quick.
Yeah, you're fine. So the interesting thing here is they filed the complaint jointly. And they hyphenate their first names. Look at how they do their names. I've never seen that before. I mean, I know you're all caps and all that crap, but Derek-Lee, Phillips, and Cody-Storm, Voss. So it's against pretty much the same people, I believe. And it's the same form, so it's the non-prisoner complaint form, but they had to write this in because, you know, they usually don't offer 2 defendants in a civil rights complaint because each person has civil rights. Karen's a Karen. I know. Isn't that awesome? Did someone say box fort? Do we need a box fort? Just for a minute. Love the box fort. Box fort makes me happy. Okay, so he's suing the County of Smith, Deputy Peters, Deputy Rugg. Oh, another deputy, Aaron Blair. So this is a new one we're adding into the mix. And then the sheriff. And then he did not answer that.
Go back to A real quick, because I like this one. Go back to the caption, then go to section A. Because this was the first thing that I noticed. They list the defendants, but the only plaintiff that they list is Derek. They don't actually list the other individual as a party to the complaint, even though they put him in the caption.
Well, yes, because there's only one spot for one defendant, because who puts 2 people on a... Did you see how they write their names, too? It's got to be lowercase.
Of course.
And it's hyphenated, and then...
Of the clan.
Of the family.
Yeah. So we have somebody in the caption who's not actually listed as a party in the complaint, just so everyone's clear.
Well, he's supposed to be. There just wasn't room for it because you need to revise your form because we want to put as many people in there as we want.
Yeah, God forbid you actually type up an actual complaint.
So this is all the same stuff that was in hers.
Yep.
It occurred at the same place at the same time.
But remember, if it's in all caps.
Yeah, don't put their name in all caps. And they don't use their, so look, they don't use their last name. Jonathan Peters infringed on Cody Storms. His name's Cody Voss.
Yeah.
Storm is his middle name, but whatever, we'll go with it. Right to travel. Dear God. You want me to read it?
Yeah, go for it for a little while. I'll pick up whenever you
Okay.
want. Just let me know when you want me to switch over.
Jump in whenever you want. Jonathan assaulted Cody Storm by grabbing Cody. Jonathan uses coercion to, oh dear God,
Obtain
Cody's ID under duress. Derek Lee stated vocally, Derek Lee was there to ensure safety.
I'm sorry. I looked up.
You remember that
I looked up the
dictionary?
mother's complaint independently. Meg sent me this one shortly thereafter, and I was reading this at like 2 a.m, and I actually thought I was drunk.
I just looked it up, read a couple words, and I was like, I can't. Last night, I was like, I will wing this one. I will do this one live without having like any idea of what it says because I can't read these freaking typos after they slammed a dictionary on the back of the car. Like I want to beat one of them. Assuring. I want to beat one of them over the head with the freaking.
But Meg, did you obtain a copy of the dictionary that they were using?
God.
Sorry.
Derek Lee was assuring proper recording of the incident addressing unlawful governmental activity. I admit I am a bad typer. I have typos all the time and y'all make fun of me. But this.
Well, you guys just spelled my name wrong in your description, so that works.
Did I?
Yeah.
That doesn't surprise me. I'm a terrible typer, but this, like, throw it in Word and spell check the shit. Jesus. Derek Lee and Cody Storm has asked for a supervisor multiple times. This isn't just words. This isn't just spelling. It's straight up grammar too. And no, they both went to college, whoever said that.
There's no way.
That's what I saw.
Can we start a GoFundMe to get their tuition back?
Can we get him some hooked on phonics?
Yeah.
Riley Rugg shows up instead of a supervisor and escalates the situation. Jonathan Peters already had Cody Storm's ID in his hand, but instead started approaching Derek's garage with Riley Rugg. Derek Phillips, in one thing he's Derek Lee, and the next one he's Derek Phillips. Can we have some consistency? Tells Riley Rugg to get off Phillips' property. Along with Jonathan Peters, defendant Rugg and Peters violently attacked Derek while Phillips was standing in his home with his mother, Karen Phillips, elected official.
Wait, hang on. Pause for a second. Isn't it Cody Voss and Derek Phillips?
Yeah.
So how can Derek be standing in his garage while they're violently attacking the same person in the driveway?
No, in the house. He's standing in the garage while they're violently attacking him in the house while he's talking to his mom.
Uh-huh.
Derek Phillips tells Riley Rugg to get off his property along with Jonathan Peters. Defendant Rugg and Peters violently attacked Derek while Phillips, was standing in his home with his mother, violating his First Amendment freedom of speech of the press and to redress his government with grievances.
Oh, dear God. That's not even a proper quote, but okay.
Yeah.
I don't even know why I'm standing on that one at this point.
They witnessed it, were recording it. Peters, who stopped Cody Voss on Phillips' private property he tried to stop him on a roadway and he kept going onto the private property.
Correct.
Physically assaulting Cody Voss and violating Cody's Fourth Amendment right to be free from unreasonable searches and seizures. Peters did not like the words Phillips was speaking. Peters
Wait,
and Ruck.
again? Unreasonable.
Unreasonable search and seizures.
Okay.
Peters did not like the words Phillips was speaking. Peters and Rugg kidnapped Phillips for speaking non-threatening, non-violent words. Jonathan Peters kidnapped Cody Storm for I need that the girl, the D's
For
nuts
fail
girl
to ID.
that Mike has, that I've been kidnapped.
For fail to ID.
For fail to ID.
When they had his ID and no corpus delicti crime had been committed by Cody Storm or Derek Lee.
Mm-hmm.
Okay. Your guess is as good as mine. Rugged Peters
Go ahead.
violently attacked Derek Phillips for recording and speaking words. Rugged Peters attacked Derek while he was standing in his garage in his home. That's okay. That's contradictory, but okay. And Peter sat on top of Derek's head, neck, and chest, causing extreme pains, shortness of breath, with extreme weight and force.
He couldn't breathe.
While Ruggs caused lacerations to Derek's face, causing bleeding in 3 areas on Derek's face. Oh my God, they actually do know what an apostrophe is. They found it on their keyboard.
He had little tiny scratches on his face, and they had to call EMS for him.
I'm just shocked that they found the apostrophe because they haven't been using it before.
It was autocorrect.
Peters was attempting to break Derek's wrist by twisting it after he had already been placed in handcuff restraints. They both continued this use of excessive force. Let's play the pronoun game. Who is they? After standing up, Rugg was pushing Derek forward, raising his arms upwards while he cuffed behind his back, causing extreme pain in Derek's shoulders until forced onto the cement ground outside. Would anyone like to diagram that sentence for me?
He went limp like a 3-year-old.
After
I
standing
almost
up,
thought we should read this as we were going through the video, but then I knew that would take us forever.
it would. This is still going to take us forever, but that's okay. Riley's assault on Derek, a restrained man, was witnessed by Cody and Karen. Ruggs doing without an apostrophe, because apparently we forgot about that now.
No, honey, there's so many things wrong.
I know, but I'm going to pick them up as I
comment.
go.
He said non-English speaker here, but shouldn't it be
No,
words?
yeah, everything. Creed, everything is wrong. Literally everything about this is wrong.
Please don't try and understand this English, because it's not English.
I am skipping over every, I'm going to comment on every third grammatical fuck up. Sorry. Because otherwise we'll be here all day. Ruggs doing this caused both of Derek's, now they learned the apostrophe again, knees to be cut open, causing bleeding in an additional number 2 areas on Derek's body. While Derek was sitting on the ground in handcuffs without a comma, Rugg was using extreme force and pressure to push downwards on the top of Derek's back, causing extreme lower back pain. I don't see that in the body cam footage.
It doesn't matter. The dude had just run off.
No, I know. They had every authority in the world to do it. I just didn't see it actually happen. Because Karen's entire argument is that they made up the affidavit. Yeah.
Maybe they should have got it to write it.
No kidding, Creed. Karen Phillips is a witness that was standing there recording, and this is visually present on her camera. That is not how Eddie. Okay. Ruggs did not like Karen recording, so he used physical force by swinging his right arm, striking Karen, an elderly woman, with blunt force. While recording, I did not see any of that.
Why would she not put that in her case?
That would be in her complaint.
Like,
That would be
he
one of the first
assaulted me.
things.
That's huge.
That would be one of the first things in my facts and evidence. If I'm arguing under a 1983 action, if a police officer struck me, that's front and center.
No wonder they want her out.
Ruggs did not like Karen recording, so used Phil's force, blah, blah, blah. Ruggs and Peters picked Derek up by his arms behind his back, not allowing Derek's feet to touch the ground, tearing ligaments in Derek's shoulder, intentionally causing damage to Derek's, and now we forgot the apostrophe again, physical body. Carrying Derek to their patrol, now we have a comma, vehicle, which is not, okay.
Do you remember when he was walking Cody to the vehicle, Derek was yelling at him, make him drag you.
Yeah.
So when they were walking him to the vehicle, he went limp and made him drag him.
Yep. Derek is still repeating his request for a supervisor, but Jonathan and Riley insisted on violence. Jonathan locks Cody in the back of Jonathan's, again, we're not using apostrophes anymore, vehicle when Cody was requesting for peaceful communication, proving beyond reasonable doubt that Jonathan was not seeking peace. What the fuck does that mean? Sorry, I know, I keep doing it. I'm trying.
No, you're okay as long as you're not in the very beginning or very end.
Yeah, I promise you, I'm trying not to. Rugg and Peters kidnapped Derek Phillips and Cody Voss. I thought it was Cody Storm.
I know. They go back and forth. I think it's like who's writing it. Oh wait, did I go too far?
No, you can go to the next page. Rugg transported Derek to Smith County Jail. The Smith County Jail, but okay, we'll let that go. Where the nurse on duty was advised of the extreme chest pains. By whom?
Remember he kept saying his chest hurt, he couldn't breathe. The second they put handcuffs on him, he started saying he couldn't breathe.
Yeah, BS. That's just literally the go-to anytime you're being arrested these days. If you can't breathe, you can't talk. TJ is absolutely 100% right.
So they took him to Mother Frances Hospital in Tyler, Texas, where Derek was refused treatment and given a release form and taken back to the jail.
Bull.
I'm going to say they looked at you and said there was nothing wrong.
Yeah.
After he was released from jail, he went to Clear Lake Hospital in Houston and received proper treatment and examination. Derek and Cody also received a traumatic shock to nervous system by this abrupt assault, captivity, and lack of nutrients.
Go screw yourselves. I'm sorry, but for the record, I have done defense work on medical facilities that actually did not provide proper care. And I represented those facilities or the doctors employed therein. And every single time when we found that their actions were not in accord with appropriate standards, we would recommend settlement.
That's what they're wanting here. They're wanting a settlement because
that's not going to happen.
Because they know how much it costs to fight it. So hey, let's make their lives hell and make them give us money because we have a reason. And they orchestrated this whole thing.
But here's the problem: the father is part of the county commissioners council. So he loses his vote. He needs to immediately recuse himself. And do you think the rest of the county commissioners are going to want to reward this behavior?
No, none of them will.
They are dead in the water politically next election cycle.
I almost think that they're going to bring someone in from outside the county.
That were my campaign strategy. Yeah, these people are absolute assholes. I am going to personally make sure that they don't see a goddamn dime from any of this because I'm looking out for you all. because I don't want to see another public apparatchik try and use our county against you and your citizens and your sheriff's department the way that these two did.
Yeah, they would.
That's an award-winning campaign strategy.
Absolutely. So it gets worse. Lance Phillips, if you remember Lance was drug out of the city council meeting.
Council meeting, yeah.
Was home at the time. Sephorid from high blood pressure and shock, not being able to sleep the night of Derek's unlawful arrest and kidnapping due to panic attacks. Lance states he noticed stalking towards the Phillips family by constant presence of the Smith County vehicles and slow rolling down County Road 37. All right, you ready for this?
All right, let's do it.
So now this was filed. Notice they're rightfully owed their fees. Cody Voss. Damages totaled $150,500,000.
Yep.
The basis for this claim comes from truth.
Ah, good. I hope it came from you guys.
Freaking psychos.
Let's see the motion to dismiss. I'll take that one. Because this is an absolute travesty. And honestly, I think that this entire family is pretty much done in the county. I can't imagine any of them getting reelected again. And I think Texas has a 2-year cycle. If you want to give me a minute and a half to do the caption, I'll pick up from there and I will give the legal arguments why the dismissal is absolutely appropriate.
They just picked 150 million because they just picked 150 million because.
Yep, that's just the number they came up with. There's nothing to actually substantiate it. If there were, it would have been. If there were, it would have been part of the actual suit.
Pretty this is.
I don't think that these people. All right, I gotta put on the camera again. I don't think that if you put both Cody and Derek together in their entire lives, they will ever do anything whatsoever that gets them anywhere close to $150 million in value to society. It's just not going to happen.
They won't get it close to $150. I don't know what you're talking about.
Well, I mean, between the two of them, they've
They could pick up pop bottles.
They've got 120 years left, and yes, they could pick up pop bottles at 5 cents a piece.
Pick up pop bottles.
Maybe they could break $100. I mean, hell, if they actually got jobs, maybe they can break $1 million in terms of just pure income. But there is not a shot on God's green earth that these two together will ever be worth $150 million ever in their entire lifetimes.
No.
It's just they're done.
So this is the response to the motion we just read, and this is just for the two.
Sorry, just to correct you real quickly, it's the complaint.
I'm sorry, the complaint. Yeah, I'm getting tired. Words are gonna get.
No, it's okay. I just want to keep it clean.
No, please correct me, because at this point in time in the evening, my brain stops sending the correct words, or I have trouble finding words.
No, it's all good.
So this is I looked at the attorneys' names at the bottom, and it looks like it's outside counsel.
Yeah, that happens very frequently when
yes, I'll get you
when a state official is sued. Very frequently, they will appoint special counsel outside of the actual. I guess in this case, it would be county solicitor's office, because you want to have that sort of separation.
That's what I
thought.
thought.
A lot of times they'll farm out a contract for somebody to represent the county when the county is directly being sued.
Makes sense. Good. Okay.
Yeah.
So this is for defendants Peters, Rugg, and Blair. Which are the defendants?
This one, because this is Peters, Rugg, and Blair, they're the sheriff's deputies. That might actually be counsel for their union.
Oh, yeah, I didn't think about that.
That might be counsel for the union that they brought in to represent the officers.
Yeah, it's that brain fog from the damn autoimmune. Okay, just a minute. Stop being an asshole. Okay, where do you want me to go to?
No, just keep going. When we get done with the nature of the complaints, I'll pick up.
Okay, so the original complaint violated their rights. This is what they cited. This is what they said. This was their statement of issues, that they violated their First, Fourth, Fifth, Eighth, Ninth Amendments.
I'll jump in for a second there. This is a well-structured response to a bullshit complaint. And this happens sometimes where I've definitely dealt with it, where you get a pro se complaint where it's very difficult to actually parse out the legal arguments being made. And we've clearly seen that in these two complaints. So it becomes almost an extra burden on the defense attorney to try and translate their nonsense into something that is actually legal that you can respond to. And so you have to take that extra step of translating their garbage into a legal document so that you can respond to it appropriately. And I think that's what they're trying to do here.
That's got to be ridiculously hard.
It is extraordinarily difficult. I had somebody who cited Han Solo and Jesus Christ in one of his complaints. It was very interesting. He was the guy who burned down his own strip club.
Nice.
Yeah, it was.
Right.
That was a fun case.
So they violated their rights to travel, to overcome the entitlement to qualified immunity. Neither of those defendants have qualified immunity, and establish the county's liability.
All right. Section 3, pleading requirements. Under Rule 12b-6 of the Federal Rules of Civil Procedure, a party may move to dismiss an action for failure to state a claim upon which relief can be granted. In considering 12b-6 motion, the court accepts as well pled facts as true, viewing them in light most favorable to the plaintiff. Citations included. The court, however, need not accept as true conclusory allegations, unwarranted factual inferences, or legal conclusions. Citation included. To survive a 12b-6 motion to dismiss, the plaintiff must plead enough facts to state a claim to relief that is plausible on its face. In Ray Katrina Canal breaches litigation, factual allegations must be enough to raise a right to relief above the speculative level on the assumption that all the allegations in the complaint are true, even if doubtful in fact. This is going back to Twombly, and prior to that, or I think following that, Iqbal. Prior to that was Iqbal. While allegations need not be overly detailed, a plaintiff's pleading must provide the grounds for his entitlement to relief. That requires more than labels and conclusions, and a formulaic recitation of the elements of a cause of action will not do. Conclusory allegations or legal conclusions masquerading as factual conclusions will not suffice to prevent a motion to dismiss. Instead, a claim has facial plausibility when a plaintiff pleads factual content that allows the court to draw a reasonable inference that the defendant is liable for the misconduct alleged. This is Ashcroft v. Iqbal. So, like I said, Twombly and Iqbal are two lodestones when it comes to a 12b-6 motion to dismiss. And maybe at some point I'll go through the specifics of those two cases. Evaluating a motion to dismiss is a context-specific task that requires the reviewing court to draw on its judicial experience and common sense, and that is citing back to Iqbal. The complaint must contain either direct allegations on every material point necessary to sustain a recovery, or contain allegations from which an inference fairly may be drawn that evidence on these material points will be introduced at trial. A statement of facts that merely creates a suspicion that the pleader might have a right of action is insufficient. This is now going back to Del Rio. In other words, the pleaded facts must make relief plausible, not merely possible. The court is not required to conjure up unpled allegations or construe elaborately arcane scripts to save a complaint. It is particularly important that these requirements be satisfied when important immunity issues are involved. I would have liked them to have a citation for that, but yes, that is true. Defendants seek to dismiss plaintiffs' claims pursuant to 12b-6 because plaintiffs have failed to state a claim upon which relief may be granted against Smith County or the individual defendants, and the individual defendants are entitled to qualified immunity. First Amendment claim. Plaintiff Phillips alleges deputies Peters and Rugg violated his First Amendment freedom of speech, of press, and to redress his government with grievances. See docket. Plaintiff Phillips pleads no facts related to his First Amendment claim, much less facts that raise a right to relief above the speculative level. See Twombly. To establish First Amendment retaliation claim, a plaintiff must prove 1. He was engaged in a constitutionally protected activity. 2. The officer's action caused him to suffer an injury that would chill a person from ordinary firmness in continuing to engage in that activity. And 3. The officer's actions were substantially motivated against his exercise of constitutionally protected activity. And that is Bachioka v. Doge. If you can scroll down, please. I cannot do it for you. Plaintiff Phillips does not allege First Amendment violations against defendant Sergeant Blair. See the first docket number, which should be the original complaint. And when Meg comes back, she'll scroll down. But yes, this is the issue at the end of the day. Yes, Perry Rush, 100%, you are absolutely correct. This is an actual lawyer responding to a BS complaint, doing it properly, breaking it down for the court, and doing lawyer's work. And this is sometimes what you have to do as a defense attorney, is you might get a plaintiff who is pro se, you might have a plaintiff's complaint that is pro se, and you have to do the work for them so you can translate it into something that you can respond to in a reasonable way, which is extra work.
Sorry, I can't pee as quick as you. I tried.
No, you're fine. You can scroll down to the next page, though.
Oh, wrong one.
Trenton, honestly, I have no idea if it was actually a legit quote or not. I didn't give a damn, to be honest with you. It really, when it all came down to it, the issue was you burned down your own strip club and the insurance company's not paying for your own arson. But I had to translate his complaint in a similar way, where I tried to take on base value what his arguments were and try and respond to them as best I could. It just is the way that it works sometimes. Here, Phillips failed to plead facts that support any of the above elements. Instead, Phillips merely recited a portion of the First Amendment and concludes a violation occurred. True. Further, Phillips groups deputies Peters and Rugg together, making no individual allegations related to the actions of the individual deputies. To sustain a claim, plaintiff must state particular facts specifying the personal involvement of each defendant, see Fee v. Herndon, and Murphy v. Keller, etc. However, even if Phillips' First Amendment claim had been adequately pleaded, it still fails because probable cause existed to arrest Phillips. And that's Reich v. Howards. There can be no claim for retaliatory arrest under the First Amendment when the arrest is supported by probable cause. Plaintiff Phillips provided no facts. No, you're good. Provided no facts in his complaint related to probable cause. And honestly, after watching the video, I think they had probable cause to arrest him after pulling away from an investigatory detention. Fourth Amendment.
I think they had probable cause to arrest him before that when he was interfering with the traffic stop.
That would have been a lot more kind of on knife's edge. I could have gone either way with that one. But once he pulled away from the investigatory detention, then we're done.
Well, yeah.
It just videotaping and yelling from the sidelines, that one is still kind of on knife's edge in my mind.
Makes sense.
In order to prevail on a Fourth Amendment excessive force claim, a plaintiff must prove, and this is where, again, notice they are giving the standard, they're going to give the facts, and they're going to say why the facts don't comply with the standard. Yeah. Thanks, Ferry. 1, an injury. 2, which resulted directly and only from a use of force that was clearly excessive to the need. And 3, the excessiveness of which was objectively unreasonable. And this is Heidschmidt v. City of Houston, Fifth Circuit, which is the controlling circuit in the case. To establish a claim of unlawful seizure, a plaintiff must show that the arrest or stop was unreasonable. A warrantless arrest is considered unreasonable under the Fourth Amendment when, at the moment of the arrest, there is no probable cause for the defendant to reasonably believe that a crime has been or is being committed. I would go a step further, or is likely to be committed, but yeah, that's the quote that they have from Davenpeck. The reasonableness, and they don't need much more than that. The reasonableness of an arrest must be judged based upon what a reasonable officer would do. Under the circumstances, and does not consider a defendant's state of mind. Correct. Probable cause is use of force is a both objectively reasonable and subjectively reasonable standard. Probable cause is, generally speaking, a subjectively reasonable standard from the perspective of the officer based on the information they have available. They don't need to read the mind of the potential arrestee. It just doesn't work that way. The plaintiff has the burden to show a search is unreasonable. A search of a home is reasonable if 1, the government obtains consent to search, 2, probable cause and exigent circumstances justify the search, and that's it. Those are the 2 that they're relying on. They're heavily relying on part 2. Plaintiff alleges that the deputies attacked him entering his home unlawfully without a warrant and without a crime present and kidnapped him. To the extent plaintiff intends these claims to be Fourth Amendment claims, they fail. Plaintiff vaguely alleges he was attacked, but provides no further facts that would make his claim plausible on its face. Phillips pleads no facts as to who specifically attacked him, how it occurred, what he means by attacked, or facts showing his alleged injuries resulted directly and only from the use of force. Likewise, Phillips does not plead facts related to whether the degree of alleged force used was objectively unreasonable. As with his other claims, Phillips states his conclusions against both deputies without differentiating between the 2 men. Phillips does not identify the alleged actions of either deputy or which deputy inflicted which supposed injury on Phillips. Phillips provides no facts related to probable cause and no allegations as to what a reasonable officer would do under the circumstances. Indeed, neither plaintiff provides the court with the circumstances at issue in this case. Finally, Phillips does not allege unlawful search. I'm presuming it's going to be end seizure, but if you can scroll down.
Oh,
please.
sorry.
Search or seizure. He merely states in a conclusory fashion that Rugen Peters entered Phillips' sick and I love that he did the sick there because he's pointing out that you don't know how to use a freaking apostrophe. Home unlawfully and illegaling. These are all from his complaint. That's why he's using the signal without a warrant and without a crime present, and he was kidnapped. Phillips makes no mention of the circumstances, consent, probable cause, exigent circumstances, what a reasonable officer would have done, or what he means by kidnapped. In fact, Phillips' statements are contradictory, as he alleges deputies Peters and Rugg entered his home, yet his pleading identifies Phillips' home as being in La Porte, Texas, not Tyler, Texas, where plaintiffs allege the events giving rise to this action occurred. Because he has his own home, and he was staying at Mommy and Daddy's. Plaintiff Voss alleges Deputy Peters grabbed him and used coercion to obtain his identification under duress and kidnapped him. To the extent Plaintiff Voss pleads these claims as Fourth Amendment violations, he has failed to state a claim upon which relief can be granted. Voss's assertion that he was grabbed is vague at best. Voss makes no allegation as to where he was grabbed, why, how, for how long, whether he was injured, that the alleged grab was unreasonable, or whether a reasonable officer would have done the same under similar circumstances. Like Phillips, Voss does not provide the circumstances at issue. Voss makes one conclusory statement that coercion was used to obtain his identification under duress, but provides no factual support that could form a facially plausible claim. Perhaps Voss is referring to Deputy Peters obtaining his identification when he states his Fourth Amendment right is to be free from reasonable search or seizure was violated. But it is entirely unclear and cannot state a claim upon which relief can be granted. Lastly, the only allegation made by Voss of an injury is the following vague and conclusory statement: traumatic shock to nervous system by this abrupt assault, captivity, and lack of nutrients. Neither plaintiff sets forth facts that would tend to demonstrate the alleged actions of deputies Peters and Rugg were intentional. The Supreme Court and this court have long held that Fourth Amendment violations occur only through intentional conduct, and that is Watson v. Bryant, the Sixth Circuit. Would you like to pick up on C?
Yeah, before you go, before we go on, someone asked me to explain what the clerk of court did, and I actually wrote this down, and I was going to, oh, sorry, my cam's off.
My understanding was that she was the clerk of the county, not the clerk of court.
I'm sorry, the county clerk. That's what I meant. So in Texas, the county clerk is an elected position and serves as the record keeper for all official public records, which includes real property, vital statistics, civil, probate, and criminal misdemeanor records.
Yes.
The clerk's office is also responsible for recording all documents for county court, commissioner's court, and the 3 county courts at law. The county clerk is the local registrar for Smith County, providing birth and death records when the event occurred outside the city limits of Tyler. In striving for excellence in everything we do, this office has set our standards high with emphasis on professional conduct, concern for others, excellence in service, positive attitude, and honesty and integrity. This is from the Smith County Clerk of Court website. Yeah. County clerk website. Sorry, in Florida, they're clerk of courts. Everybody has a clerk of court, so it just.
Well, so, and I think that's
county
true,
clerk.
Well, the same is true in New York. There's a clerk of courts, and then there's the county clerk. Those are different roles depending upon your state. But generally speaking, the most important aspects that a county clerk has is vital records, birth and death certificates, and property records.
Yeah.
Those are the 2 most important aspects that the county clerk has fundamental control over. Depending upon your municipality, they can also be in charge of marriage and divorce records. Like you said, they could be in charge of recording misdemeanor records. Generally, felony records would go to the clerk of courts and ultimately to a state registry.
The ones I read, that's specific from her county.
Yeah. Generally speaking, the big two are vital records, birth and death, and property records. Are
Land
the two.
records, yeah.
And those land records are massively important not to screw up. So her cavalier behavior when it came to drafting her own complaint in a federal court makes me think that she might not be the most apt individual to administer that position. Fair enough?
Yep.
All right.
All right. 5th, 8th, and 9th Amendment claims. The plaintiffs list these constitutional rights were violated. We know what these say. We don't need to read that all over again. The plaintiffs have provided no allegation related to a 5th, 8th, or 9th Amendment claim, much less factual content that would allow the court to draw the reasonable inference that a defendant is liable under such amendments. As a result, plaintiffs' 5th, 8th, and 9th Amendment claims are not plausible on their face and thus fail to state a claim upon which relief may be granted and must be dismissed as such. See Ashcroft. Right to travel claim. Can we just say this is BS and move on? Plaintiff Voss claims Deputy Peters infringed on his right to travel. Docket 1 at 8. The Supreme Court has repeatedly reaffirmed the constitutional right to travel from one state to another is firmly embedded in its jurisprudence. Let's see. Citing, yeah. This right is based on the Privileges and Immunities Clause of Article 4 of the U.S. Constitution. The Supreme Court has yet to recognize a corresponding right to intrastate travel under the Privileges and Immunities Clause. However, see Dickerson. Additional citations omitted. Plaintiff Voss does not allege any fact showing Deputy Peters impeded his right to interstate travel. As a result, Voss has failed to state a right to travel claim. Federal criminal statutes. Plaintiffs mentioned 2 federal criminal statutes in their complaint, 18 U.S.C. 241, conspiracy against rights, and the deprivation of rights under color of law. Plaintiffs do nothing more than cite the statutes and state their contents. To the extent plaintiffs claim one or more defendant violated these criminal statutes, plaintiffs fail to state a valid claim. You can't just say, you punched me. You have to show some proof that it actually happened.
So 1983 is the statute under the mother's arguments, violation of civil rights. They actually got a little bit closer. They still missed, but they got a little closer where they were arguing about public officers under color of law. They're still wrong. But, so be it. But notice this is all under Title 18, which is the criminal statutes of the federal code. Criminal statutes do not convey a private right of action. See citation. To quote, there's no private right of action for criminal conspiracy under 241 or the deprivation of rights under 242. Plaintiffs cannot enforce federal criminal statutes in a civil action. Thus, any claim under these federal criminal statutes should be dismissed for failure to state a claim. In sum, plaintiff alleges, in support of their constitutional claims, where plaintiffs actually make allegations, I like that little dig, are vague and conclusory. Plaintiffs do not even state they were arrested, much less provide any facts to support an inference that the defendant's deputies lacked probable cause to search, seize, and arrest, or that any force used was unreasonable. Section 5. Individual defendants are entitled to qualified immunity. Now, this is where we might get into a little bit more of an interesting discussion, potentially. Smith County deputies plead the affirmative defense of qualified immunity. The deputies, in the course of their employment, are entitled to qualified immunity because 1, there was no constitutional violation, and 2, their conduct did not violate a clearly established law of which a reasonable officer would have known. Plaintiff's pleading is insufficient to allege a constitutional violation by defendants. However, even if there were, this is where I disagree with how they drafted, because were is a hypothetical contrapositive, was presumes the premise, was a constitutional violation, defendants would be entitled to qualified immunity. I would have used were there.
I would have too.
In the present case, sorry, this is the grammar draftsman in me. In the present case, plaintiffs have sued deputies in their individual capacities and their official capacities as Smith County deputies. Plaintiffs state that the defendant deputies were wearing a uniform and badge under authority of the county. The allegations in plaintiff's complaint establish the individual defendants acted in their official capacities as peace officers on the date in question, pulling over a vehicle, asking for identification, detaining suspects, and arresting suspects are clearly exercises of discretion within a deputy's authority as a peace officer. The qualified immunity defense has two prongs: whether an official's conduct violated a constitutional right and whether the right was clearly established at the time of the violation. And this is worth remembering when it comes to dealing with police officers. They can violate your rights, but if it was not clearly established that their specific conduct, literally to a T, had already been determined to be a violation of constitutional rights, they probably slide under qualified immunity. So that's why you don't fight on the side of the road. You fight in a court of law, because you're going to lose on the side of the road. If the defendant's actions violated a clearly established constitutional right, the court then asks whether qualified immunity is still appropriate because the defendant's actions were objectively reasonable, in light of law which was clearly established at the time of the disputed action. And the answer is there's no such thing as law that is clearly established when you're talking about qualified immunity. It is very, very easy, and Meg, you can correct me if you think I'm wrong, but it's extraordinarily easy for a court to say, yeah, what you did was wrong, but it wasn't clearly established in our case law at the time, and so you slide. I don't know. You've watched almost as many court cases as I have at this point, so if I'm mistaken, please tell me. But
I agree, especially in smaller courts, they have a lot of discretion in that.
Yes. To be clearly established for the purposes of qualified immunity, the contours of the right must be sufficiently clear that a reasonable officer would understand that what he is doing violates that right. That is, the unlawfulness of the defendant's actions must have been readily apparent from the law previously applied to a sufficiently similar situations. And that's where the defense attorneys actually, they wrote that wrong, but okay. In essence, a plaintiff must allege facts sufficient to demonstrate that no reasonable officer could have believed his actions were improper. Plaintiffs' vague and conclusory assertions simply do not overcome the individual defendant's qualified immunity. Plaintiffs have failed to state a viable 1983 claim against Smith County. Now, this is against the county, not against the individual officers. The individual officers, I think, are easily off the hook. This is actually one that's a little closer, but I think that they still fail. The plaintiffs still fail. I would phrase that differently. It would be, we found the officers did violate a constitutional right, but it was not so clear that no reasonable officer thought that they were stepping outside of their bounds. And that's usually the way that qualified immunity gets applied.
Yes.
Here, do you want to do the 1983?
It's not that they enjoy being stupid, it's that they enjoy tying up the court system and feeling like they're screwing the man, is my interpretation from watching it, but I could be wrong. To impose liability on a
Can you rephrase that for a second? Because who is the they? You're kind of playing the pronoun game on me.
The SovCits. Her question was, do people like this enjoy being stupid? Like the people I
think that they genuinely, I think some of them genuinely believe that it's actually a recipe for success, but it's not.
I don't know how you can believe that when I have never seen anyone succeed at it. Have you?
Yeah, I have.
Okay. I have never seen a sovereign citizen court
I've
case that has
seen
ended successfully.
I've seen some videos on the roadside where the cop genuinely gets bamboozled and lets them go. I have
Okay.
seen some cases of that. I've seen quite the opposite as well, but
I would say in the overall, statistically, like
I would
you're
say
not.
it's probably 95-5.
Yeah, that's where I'm like, why do you think this is a winning strategy? Because your percentage of winning is so low.
I don't know.
And some people like to fight too. Like they like being obstinate. They like being, you know.
It's an interesting concept and maybe kind of philosophical conversation for another show at some point. But I agree with you. I think that there are some people that like being contrarian for the sake of being contrarian. And you know what? If that gives them a dopamine hit and they still end up in jail, maybe that's their gamble.
I seriously want an interview as sovereign citizen. So if anybody knows one.
Oh, you do not want to do that. Natalie did that
do.
a year and a half ago, and it did not go well.
Yeah, I still want you for me.
All right. I could probably find one.
Maybe I'm just riding my judge dad high.
All right.
All right.
1983.
To impose liability on a local government under 1983, proof of 3 elements is required. 1, a policymaker. 2, an official policy. And 3, the violation of a constitutional right whose moving force is the policy or custom. Any unconstitutional conduct must be directly attributable to the municipality through some sort of official action or lawyer word, imprimatur. That sounds foreign.
It literally is Latin for let it be printed.
Yeah. See, that's why you shouldn't take online classes, because you don't learn how to pronounce anything.
You'll see it. You actually, if you go and you read a handful, or if you ever pull a book from the library that was printed by the papacy, on top of the copyright, there will be an imprimatur, which is basically official authority from the church. Let it be printed.
Interesting.
Yeah, so that's kind of in the modern context where it's most used, but yes, it basically means with the seal of approval.
Isolated unconstitutional actions by local government employees do not trigger liability. The defendant's motion to dismiss. Plaintiffs fail to even allege a policy, custom, or practice of Smith County, much less an unconstitutional policy, causation, and a policymaker who acted with deliberate indifference. Therefore, the claims against Smith County must be dismissed. In conclusion, as stated above, plaintiffs make no allegation whatsoever as to Sergeant Aaron Blair. Therefore, Sergeant Aaron Blair must be dismissed. Yeah, they put him as a plaintiff, but like literally did not talk about him at all.
They didn't say a word about him in their complaint.
I think that is the supervisor that showed up.
Yes.
And basically all he did was affirm what the charges were going to be against them. Like, that's part of what I cut out. They basically said, hey, this is what happened. And he said, okay.
Yeah, my understanding from the larger one is like, this is, we had a little bit of that clip at the very beginning. But they were like, we have this, and this. And he's like, all right, sounds good. And that was the extent of his involvement as far as I could tell.
It was like 10 minutes of them kind of walking back and forth and talking about it and stuff. So the allegations made by Plaintiff Phillips against Deputy Peters and Rugg are group pleadings that do not describe any deputy's alleged role in the interaction with Phillips, and thus do not sufficiently plead a 1983 claim against either deputy. See Armstrong v. Ashley. Armstrong's allegation also suffers from the distinct problem of group pleading. She simply faults the 8 law enforcement defendants as a group without factual material suggesting that any particular defendant suppressed evidence. Armstrong's allegation is independently insufficient for that reason, since a 1983 plaintiff must plead that each government official defendant, through the official's own individual actions, has violated the Constitution. Citing Ashcroft, Southland. All right, we're going to skip the citations. As a result, Phillips' claims against Deputy Peters and Rugg must be dismissed. Plaintiff Voss' claims against Deputy Peters are vague and conclusory at best, and fail to state a viable claim. The extent of plaintiff's pleadings as to Smith County as to name it as a party. Thus, Smith County should be dismissed. Ordinarily, a pro se plaintiff should be granted leave to amend his complaint prior to dismissal. However, leave to amend is not required where a plaintiff has already pleaded his best case. Brewster.
You're going to ask for dismissal with prejudice.
Here, plaintiffs pleaded their case using a complaint for violation of civil rights form provided by the court. The form provides sections calling for specific information and providing in detail the information required, relevant cases and statutes, the specific requirements of 1983, instructions on what to describe in the statement of claim section, a list of additional information for the plaintiff may wish to include in the statement of claim section, examples of the facts underlying your claims and instructions, yada, yada, yada. Told him what to say. Whereas, premises considered, defendants Smith County, Texas, Jonathan Peters, Riley Rugg, and Aaron Blair pray their motion to dismiss be granted and that all claims against defendants be dismissed with prejudice. Sincerely, a bunch of lawyers.
Yeah. Shockingly, a bunch of lawyers wrote a much better documents than the plaintiffs did.
The end for today.
So let me ask you, and I'll throw it out to the chat. You have me for a little while. Does anyone have any questions on how you think this one's gonna go? Or any questions about kind of the dueling complaints?
Yes, Perry. I think that they're going to dismiss it, and then they're going to try and get her fired, but I don't know if they're going to be able to.
Okay. Do you think they're going to dismiss it? Well, I know we only have the one response, and Wombat, Meg is not a lawyer, but she is extremely well-versed.
I have a...
That's why I really appreciate being able to consult with her, because a layperson that's well-educated in the law is more valuable than a lawyer in a lot of cases.
I went to school and I got my associate's degree in paralegal studies. Then I got a bachelor's degree in legal studies. I was planning to go to law school, but I ended up going and getting my MBA in social media analytics and research instead.
Yep.
And now I sit and talk to people on YouTube.
And you all know my history. So I have all of those things on the wall. Do you think that they're going to dismiss it with prejudice, though? Because that's really strong medicine, but I think that it might be appropriate in this circumstance.
But he literally didn't state a single valid claim. Like, there was... Everything was just... Like, somebody said copy pasta, word salad. It was just a lot of words, but there wasn't anything like, this person did this and it violated this. There was no specific action tied to any specific claim.
I agree with you. However, because they are pro se, 3 VOM makes a very good point. I believe courts are fairly loath to not give a pro se a second chance if they learn their lesson. No, that would require that they actually understand how to do motion practice, and they clearly don't. I mean,
but that would cover them from not being able to.
If you had a lawyer, you would basically file a motion in concurrence with the motion to dismiss, requesting to dismiss without prejudice and a right to amend.
So look at it this way. If this was a business, wouldn't this be considered like a slap suit almost?
No, because that specifically goes to First Amendment. So a slap suit, those statutes are specifically a strategic lawsuit against public participation. So the lawsuit has to be against the defendants engaging in First Amendment activity. So the two are not really comparable. But I understand where you're coming from. It is an absolute, it's a harassment lawsuit. I agree with you there.
It's frivolous.
It's frivolous. I agree with you.
It's frivolous on its face. There's really not a single basis.
But I still think that federal judges, generally speaking, are loath to dismiss with prejudice the first time that a pro se comes forward.
But what else are they going to do? What would be the next step?
Dismiss without prejudice and let them refile, or let the statute of limitations run out. I mean, what's the SOL in a 1983 action? I should know that off the top of my head.
Because if they dismiss and let them refile, they're just going to refile the same garbage. I mean, that's hopefully whoever is involved in this case would have some kind of knowledge of I like to call it the Sovereign Citizen Handbook, the way that they handle things, and that they're just going to try and tie this up in court forever to cost money to try and get them to settle or do something beneficial to them.
And I tend to agree that, I tend to agree with you there. However, I think that they've demonstrated fairly clearly that the county is not going to settle this one. They're going to let the voters ultimately decide. But I guarantee you, it looked like it was a council of 5. I guarantee you that that commissioner probably does not have a lot of friends on the county commission anymore. And probably is not. Yeah. Thanks. Not sure that there is necessarily one.
Well, wouldn't it just be on
let's see. No, that's
7 years.
I think it's 7.
It is 7. Look up civil rights violation.
Yeah, 7 years for those not resulting in death.
And there's some of them that are less, like a workplace.
I think workplace
discrimination is 4.
4 or 5, yeah. And then a discrimination on contract, I think, is 2 or 3. So yeah, there are shorter ones, but 7 is usually what your SOL is on most criminal violations. I mean, replevin, you
Especially
usually
in Texas.
get longer.
So basically, I think the bigger question is going to be, are they going to be able to keep their jobs?
That's up to the voters at the end of the day.
Because then she could potentially have, because this was just a sack of poo with everything thrown in it, everything but the kitchen sink. If you take and piecemeal that out and actually pay attention, she could actually file a claim against, workplace discrimination or something along those lines, if that's what she was going for. She kind of started to go down that road, but didn't quite go there with the whole people aren't being nice to me at work.
Yeah, but the problem there becomes, what is the actual nexus that started it? And
the sheriff released the video, and the sheriff is under the same employee as her.
Well, but let me go one step further back. The nexus is her behavior on the video.
Her son technically would have been.
No, because here's where that kind of diverges a little bit. Because if I'm not mistaken, she did invoke her position as county clerk to the officers, and that was part of their affidavit that she objected to. So if she did invoke her official status, then boom, this is no longer a private engagement. You're now acting as a public official. If you had never done that, then maybe you'd have an argument. But the second she did, she transformed herself into a public official for law purposes.
That makes sense.
So I think that she kind of did that to herself.
Oh, I totally think she's in the wrong. Completely. I think she's a Karen of all Karens. Like,
but at the same
how
time,
dare you act like an asshole, then turn around and file a $10 million lawsuit? Seriously? Because someone at a drive-thru was mean to you? Wah. Like, don't be a jackass. And teach your kids some manners. But I'm just looking at ways that this could get drug on for years and hurt the county that she's in.
It can.
Because if she stays in her job.
If you have a clever attorney and they don't vote her out, I mean, I don't know when the next election in that county is going to be.
I had it up earlier.
But
if anyone ever wants to know anything like that, Ballotpedia.
Yep.
Wikipedia isn't. Okay, so she was just elected in last year, March 1st, 2022.
So what is it, a 4-year term?
Didn't see it on this page. So where is the clerk, Smith County Clerk? There's no link to that. There's not much information.
Hang on. Give me a second. I'll get you an answer. There was a question about being vexatious litigants. I don't know if you want to answer it first, then I'll give my opinion.
What was the question? Vexatious litigants or assholes? Okay, so it must be 4-year because there's nothing in here for 2020. Oh wait, election required. Maybe there is, and I'm just looking at the wrong thing.
No, it's okay. You take care of that. I'll find it.
Oh, here it is. Melly, it takes a lot for someone to be labeled vexatious and like actually prevented from filing further lawsuits. I mean, a lot. Take oh, what's his name? I can't words. What? Danson. What's? Someone tell me his name. Who's the Danson guy in Vegas? I see a K. I see a B. What the hell is his name? John, what's his name?
Who am I looking up?
No, you're not looking it up. The guy in Vegas that Blandino, Kim Blandino. See, I had the K and the B right.
There you go.
The threshold, yes, is a literal shit ton. I mean, look at what Blandino. Thank you guys, Blandino. It's just this, for some reason this is so slow to come through with comments. It's gosh, he sued like 10 different people at least, multiple times over like the course of years, and it got to the point where he had multiple lawsuits going, and he was suing this judge, and when it got transferred to another judge, he would sue that judge. It got transferred to another judge, he would sue that judge, so that the case couldn't be heard because it was a conflict of interest until it got transferred out of the county, and then he was doing stuff like that. So you have to be like unbelievable in order for that to happen. But there have been some sovereign citizen cases where they've been banned from filing further lawsuits because they get out of control, and it's all BS. I'm not sure if you guys saw the stream I had the other day, Mr. Ross and Judge Simpson, where he tried to fire Lauren Brown, who is an amazing public defender. I'm actually going to follow up on that this week when he has another hearing. But he starts rambling off all this crap because he wanted Lauren Brown to file his motions. And like, I had to sit and write down every word he said because he didn't make sense. His sentences did not make sense. It was incoherent. And when people start just filling the courts with crap like that, at some point they can say no. But in this case, it wasn't quite that egregious. They don't really have enough cause to do anything about it. They would have to file quite a few lawsuits continually for multiple causes to really be to get their hands slapped, basically.
And that's generally speaking true. I mean, we've seen that certainly in copyright cases. I mean, look, Southern District of New York, I will not use the name of the attorney, but if people have followed Leonard French, you know who I'm talking about, has basically said, look, you need special permission to file in our court ever again, period. Otherwise, go away. You're done. You didn't actually technically violate any rules of your licensure. We're just not going to hear you. Goodbye. So it does come to a point sometimes. Less it's a matter of vexatious lawsuits. It's less a matter of a vexatious litigant than a vexatious lawsuit. And that's when you end up requesting attorney's fees as part of your addendum is, look, Your Honor, this is such a stupid motion or this is such a stupid complaint that I should not be held responsible for having to defend myself. And so I would like the plaintiff to have to pay for my attorney's fees. And sometimes they will grant that to you. I see that a lot of times. I saw that a lot of times when I was doing foreclosure work, was because we have all the paperwork and they want to fight it. Okay, you can fight it. You're going to lose because we have the proof that we have the note. Here's the mortgage. Here's what you have in arrears. Here's the proof you never paid us. Why do you have to hire us to prove this in court? Pay our fees. So in individual circumstances, it's much more common than getting a person kind of banished from the court or has special sanctions on them in terms of what they file. But it does happen.
They can tell them you can't file any more lawsuits in this case. You can't file any more motions in this case if they're stalling a case by filing frivolous motions. I have seen that.
They can.
But it's pretty rare that the court is going to order anyone to do anything because you have to worry about infringing on their rights. Even jackasses have rights. It's
quite rare, but it does happen.
But it has to be an extreme circumstance to trigger it, I think is what I was trying to get at.
Yes, that is absolutely true. It does have to be something relatively extreme. And I'll give an example. There was an attorney that lied about the date of his father's death, and the judge wasn't having it anymore because he had been continuing this case. It was a harassment lawsuit over a copyright claim. And the judge wasn't having any more of it and said, all right, give me an obituary, give me some proof that your father actually died so you couldn't show up to the court date. And he wouldn't, and it went on for about 6.5 months. I actually covered it. This is months and months ago now. And judge got fed up and basically said, you know what, look, you're a liar. You lied to this court. I am fining you $1,000 a day until you either give me proof or you admit you lied.
But that's an attorney as opposed to,
Yeah, but obviously pro se
they're held to a higher standard.
Yeah. But he ended up paying like 14 grand, and then after that, he was referred to the state bar. Was given a 1 year and 1 day suspension, if I recall correctly. And the reason why that's interesting, and I've said this before, is anything over a year, you have to take the bar exam again.
Oh, ouch.
So 1 year and a day is meant precisely to send that message, because the court doesn't want to take away your livelihood, but they're sending a message. You have to take the test again because we don't trust you anymore.
Down on your knees, boy.
Yeah. So that was 14.
There's some kind of craziness in the comments about objectifying you, calling you daddy, but being old enough to be your mom. I don't know. You're going to have to go through that later because
I don't know. I didn't particularly notice that, but
that looks a little exciting.
Is that from my side of the chat or yours?
Oh, that's totally yours.
I didn't see it. All right. I'll take your word for it. But yeah, no, that was, so it does become interesting when you actually do frustrate a judge enough. And we see kind of small pieces of it when you, for instance, see where the judge throws them into contempt for a couple days or whatever every now and again. But when it comes to...
I know, my chat's always good. Look at my dog sitting there being all good. Like, I got control of this shit.
My chat's usually pretty good, but...
John's like out of control. They're like, we're back, taking the shirt off, swinging it around their heads.
Well, it's like, have you ever...
Daddy's home!
Yeah, have you ever taken a vacation and you come back and your dogs all jump on you? They have absolutely
no... That happens when I walk to the mailbox and come back.
Fair enough.
But I did learn, because I had to look this up, because I couldn't quite understand it, dogs have no sense of time. So whether you're gone for like hours or whether you're gone for like 5 minutes, they really don't have that concept of time. The vet kind of gave me a whole...
You're right about that.
The vet told me about it. Like, when they sleep, they don't have like a sleep-wake cycle or anything. I mean, smarter dogs probably do, but my dogs aren't very smart.
Well, I think, I'm trying to think, because Stephanie's dog, she knows to leave us alone during the nighttime hours. But around 6 o'clock or so, I have a tendency to wake up, like try and roll over and fall back asleep, and she thinks that I'm awake for the day. So that doesn't quite work so well.
Yeah, mine have taken over my side of the bed. Even though they have their own side of the bed. Like, now we're all sleeping on like the twin side of the king size bed.
Yeah.
Like, all 3 of us plus whatever cats decide to join in.
I'll
Usually there's
that
1 or 2.
That's
a lot for a twin bed. Let me just tell you.
So we have a king size bed, and I will, get up early in the morning to go use the restroom or whatever. And she immediately bolts and decides to sleep on my pillow. And it's like, okay, I guess that's now your part of the bed.
What? Like, is it because it's warm? I don't get it.
No, but every single time. Every single time.
It's dark. And do you know how often I sit on him? I'm surprised he has any brain left. I squish him every morning.
Oh no, I've literally gotten to the point where I'm like, all right, congratulations, Sophie, you're now the pillow, and I'll just go back to sleep on top of her.
I get extra pillows. They have their own pillows. Here's your pillow on your side of the bed. Let's move over here. No, I want that one. Okay, we'll take that one. Nope, I want that one. Spoiled little assholes.
Yeah, well, you know. So what do you mean when I go full Willy Wonka? What are you talking about?
I didn't see any candy.
I'm not gonna suddenly get a purple suit and a brown top hat. Although I'd probably look pretty good in it.
Well, that was quite a show.
Yeah, I
Haven't
mean,
done this in a while.
welcome back to my world where shows last 4 hours. It's been a while now.
I haven't done this in a while. I don't do lives very often, so.
Nah, you're good, Wombat. Don't worry about it.
Yeah, but Rick's cute, so Rick's a cat. How cool is it? She's got a cat named Rick.
That's pretty good.
I know. Mine are named like Rambo. That is cute. So we will keep following up on this case. I have no idea what's going to happen, but I'm pretty sure it's not over. And we also have that TikTok to investigate to see what's going on with.
Yeah, because you just found that this morning. That would be interesting to see what's on there.
Yeah, I did stumble across it because I was trying to look it up because they said that they were kind of baiting the cops in videos, but I couldn't really find any evidence of it, so I didn't want to mention it if I couldn't find anything to go along with it. But
I mean, you know, until we can find corroborating evidence, that's why I always like going back to the actual documents, is because they're publicly available information that I can interpret. On my side, I was reading the complaint that DeSantis in the state of Florida filed against the federal government regarding private accreditation agencies and the constitutionality of the delegation doctrine to private entities. A lot of people are dismissing it. I think it's more interesting than people are giving it credit for. So that might be something that I'll do in the next day or so. If you'd like to join, you're obviously always more than welcome.
no, not if.
But that's
he makes my acid reflux flare up. There was something that he did the only.
You're married. Stop.
Like all of him, or like just his feet, just his hands? Like
Jesus,
I need more details
stop.
here. Well, so I've been told that, you know, there's lots of fetishes on there. I've never quite looked.
Right, I'm
but
turning off the cam because I need a cigarette after that one, and apparently we're not allowed to do that in the last 8 minutes of the show.
Nope. There was something that DeSantis did the other day that I saw in the headlines, and I thought it was something good for you. But
he did actually.
if I know what it is.
That's an interesting law that is kind of like a small thing that most people wouldn't notice. But I thought it was really important and valuable. So there has been a law in the books for decades at this point that if a defendant in a courtroom attacks court staff, a judge, the prosecutor, etc., it's a felony. But it did not include their public defender. And so I guess it was probably February of last year, a guy cold-cocked his public defender, broke his jaw, and fractured his skull.
Mm-hmm.
And they finally were like, okay, everybody, all lawyers in the courtroom need to be protected, all staff, the judge, everyone. So they finally fixed that so that it's still a felony, because they ended up sentencing the guy, and the judge is like, what you did was absolutely heinous, but because of the law, I can't sentence you to more than a year.
I did not know that that was an exception. Because that's happened quite a few times.
It wasn't included under the felony statute. Yeah, he
broke his lawyer's jaw.
Yeah.
punched. Sometimes you gotta, when they
he
say
punched-
what, you gotta use another word because they're on the other side of the pond and don't know what cold cock means.
Yeah, no. So he punched his attorney in the face, fractured his skull, and broke his jaw, and they couldn't give him more than a year. And so they decided, all right, we're gonna recalculate the law in order to include defense attorneys under that protection. So I thought that was pretty good.
This wasn't the one I was looking for, but he vetoed a law that was related to expunging records. And that was just today. It was a bill offering a second chance for criminal records to be expunged. I can't remember what it was, but it was something along those lines. It was something that wasn't really.
I'm generally familiar. I did not read the actual bill text. I'm a little bit divided on that one. I do not have a particular opposition to it.
It's called First Step Act. Well, he vetoed it, so it's not happening.
Well, so the First Step Act is that was probably the first problem, is because that was the same phrase used, and I imagine it probably came from the same think tank. Because what people a lot of times don't realize is that legislators do not write their own bills. They're written by think tanks and they're handed to them, and then they propose them.
Or they're written by everyday you and I's that have a job related to
that. A little bit more of the first one.
Depending on what it is, like the important stuff that are related to criminal law and stuff like that, yes. But for example, when I was working in child nutrition and we were lobbying for certain laws, they actually asked us to write the text of the law, our association, and send it to them.
Right, and that's what I refer to as think tanks, is lobbying groups, because they don't want to be bothered to actually write the stuff themselves.
We weren't really like a lobbying group as much as, but yeah, it's this.
For what it is, it can be good. It can also be bad. First Step Act was modeled off of the federal government's First Step Act, and which was even before that modeled off of New York's First Step Act, which caused all of the bail reform problems that New York's currently facing. And the DeSantis office basically was like, yeah, we're not going to do that. So I don't personally have an issue with him vetoing that one. Just because it seems like it's not necessarily a bad goal, ultimately. It's just too much too fast, if that makes sense.
Yeah, it does.
So that's just my perspective.
If I find the one I saw before, I'll send it to you. I don't know if I will or not. I think it was just a headline that came up, in one of my news feeds. Because Florida.
I think that this legislative session, they did a lot of small tweaks that don't gain a ton of headlines that, like I said, adding public defenders under the auspices of the felony harm inside of a courtroom rule, I think that's a good thing. It's not something that's going to get you a ton of headlines, but it's something that needed to happen. And there have been a bunch of those.
Surprised the gun laws didn't make more headlines.
I know, the constitutional carry was kind of interesting. And Florida's always been weird when it comes to gun laws because open carry is still explicitly illegal, but concealed is explicitly legal.
And then also lowering the age for long guns.
Yep.
That actually got passed at the same time that they passed the death penalty law that's lowering the number of people that it takes to, I think that might have been what it was. So there's a case going to trial. Either it's in trial right now or it's about to go to trial, that he was charged prior to the passage of the new reformed, it only takes, 8 out of 12 votes for the death penalty in Florida because of what happened with the Stoneman Douglas, Nicholas Cruz, you know, 2 people flipped the whole. thing so that a rogue juror can't.
In fairness, the Supreme Court's already answered that question.
What?
It is unconstitutional not to have a unanimous verdict of death. Supreme Court's already said that. And so this is trying to bring it back up and see if they'll overrule themselves.
Well, the question is that they weren't questioning the law itself. They were saying that I was convicted or charged before this law went into effect. So the law that was in effect when I was charged should apply.
Right. And I get the argument there. The problem that you have as a matter of practicality is ex post facto laws generally apply to the criminality of the conduct, not necessarily the sentence.
Mm-hmm.
So, for instance, if you were convicted before, I don't know, let's say Florida decided to outlaw the death penalty, but you were convicted before that, can we still enact the death penalty, or do you want the benefit of the new law? Does it only ratchet one way? Or how do we parse that out in a fair sense? My perspective would be that you are subject to both the crimes or the criminal statutes and the penalties at the time of the offense. Because
the prosecutor filed a motion to charge him under the new sentencing guidelines, or
right. So I would actually.
He argued it would make it easier for me to get the death sentence under these new guidelines.
Right, and I would, generally speaking, I would agree with you that you should be held to the definition of the crime, your conduct, and the sentences available for that compilation at the time that the offense occurred. I think that's a very easy, straightforward way to apply the law. I don't think that you should be applying the new death standard to prior acts. I just don't. I think that that's probably not fair. And look, I am probably amongst kind of the law tip community the most pro-death penalty person you'll meet. But no, I don't think that it's appropriate. If you committed the crime understanding that the consequences could be X, they can't change it to Y during the course of your incarceration in that sort of a way. I don't think that's appropriate. I don't think that's fair. I don't think it's appropriate notice.
But what's somebody going to say? Oh, well, if I would have known that it only took 8 people to give me the death penalty, I wouldn't have killed him.
I don't care. That's really not my concern.
Yeah, that makes sense. That's how they handle, offenses.
Correct.
For charges,
it wasn't illegal
what
at the
the
time
law
was. It wasn't illegal at the time that I did it.
Right.
You can't then create a law that's ex post facto law. I think the same principle should apply to sentencing.
So what do you think about all of the people who were sentenced for, say, marijuana possession? For significant sentences.
I think they should serve the sentence that was appropriate at the time that the offense was committed.
Even though, before they're even released, it's legal.
Yes. Because
I'm just curious. I'm not judging in any way.
Think about it this way. My perspective when it comes to criminal law is we have a set of rules. The issue is not, in some ways, even what you did per se. It's that you broke the rules.
Yeah.
That's
completely.
the state has. So even if it's a stupid rule that ultimately gets overturned, I don't care. You broke the rule at the time. You did it knowingly. So you suffer the consequence of having broken the rules. It's not that what you did is particularly bad. I don't give a damn if you want to go smoke weed. I really don't care personally. But you broke the rules. Those were the rules. You knew them. You knew the potential consequences. So you suffer the consequences. And if years later that goes away, It doesn't matter. You still broke the rules when you did it. I think that's the only way to be consistent in trying to apply the law to criminal statutes. It's
No,
what
and
was
I
it at the time when the
absolutely
offense
agree.
was committed.
I agree. I
It's
was
it's
curious
the only
what
way
you
to be
thought.
consistent. And I'm really tired when it comes to federal drug offenses, and this is one that Trump pissed me off on, and I've talked about this before. But when you're talking about the nonviolent drug offenses, most of those were not actually nonviolent drug offenses. It's just that the FBI drops them down to possession because they know that they can still get a 20-year charge out of it. And when you're dealing with federal prison, you're spending the full 20 years. So I don't care if it was trafficking, if it was money laundering, if it was whatever. If I could drop it down and throw you in prison for 20 years and you're, 45-year-old, I don't care anymore. It's basically the way that the prosecutors operated. So the idea that, everybody, all of these people in federal prison are nonviolent drug offenders, no, they pled down to a nonviolent drug offense crime from something much more significant. I mean, hell, the woman that Kim Kardashian was standing up for and got this whole ball rolling, I think, what was it? She was arrested with like $7 million in cash and was a major trafficker. But
Oh, she's got a Netflix show.
put down to a possession charge, and she was the one that they let go and started this whole ball rolling. It doesn't. There's more stuff that goes on behind the scenes than we are made aware of when it comes to drug crimes.
Oh yeah, and they're all pled down. I mean, they hardly
Correct.
ever take them to court because when they do, then you end up with something like the YSL. There's too many acronyms and cases. I keep getting the MELI and the YSL cases confused. YSL case where it's going to take a year to prosecute everybody.
Correct.
How much money, and it's just unbelievable.
Well, and that's part of the
tax,
problem. It's just extraordinarily difficult and extraordinarily expensive. So it's easier to give a mandatory 20 years rather than, really has practical sense. If they really wanted to go after the full trafficking and they wanted to RICO and they wanted to go after, it probably would have been the equivalent of what would have been life in jail forever. But it's not worth it to them. So, the idea that everybody who's in for a drug offense is a nonviolent user that happened to get caught up. No, I'm sorry. If you end up with a federal prosecution for a drug offense, there's more going on behind the scenes that we just don't talk about. It just is the reality of the situation. And so I don't like those. I feel like those sort of statistics are brought forward in a disingenuous way.
But people use statistics to further their agendas, and when their agendas are to make it look that way, then they use those statistics for it. So
no, of course, and that's true. That's true of all sides.
Yeah.
No, that's true of all sides. John, are you going to cover the tarot card reader is being sued by the professor in Idaho? Well, I'm not familiar with that one. Are you?
Oh wait, Idaho.
Because I know fortune telling is a class B misdemeanor, I believe, in New York.
Was it Idaho? There was a psychic who claimed that somebody was the killer in one of the high-profile cases. I'm drawing a blank at the moment.
Well, but if you can send me the case on Twitter, I might look into it. Moscow, Idaho. All right, let me see.
It's the Koberger case, right? It was claiming that was the.
Is it? Yeah, maybe.
Yeah, it's the Koberger case. It was before they
Yeah,
him down.
like it claimed to have solved the University of Idaho murders
And named a professor. And the professor turned around and sued her for defamation and something else. I didn't know that that was actually like anything materialized out of that. I remember when it happened.
Apparently, he did file suit on defamation grounds.
I knew they filed suit, but I didn't know it.
Without reading the actual filings, my immediate instinct, because he sent a November demand letter.
Yes.
And he didn't take it down.
It was a TikToker, and they sent cease and desist, and she ignored him.
I think he wins that one.
Oh, absolutely. Like, she blatantly disregarded all of the nice requests to do the right thing and basically said, screw you all, and went with her theory because she knew the answer to it all.
Yeah.
And
I think he wins that one. Just I haven't read the actual filings, but just on its face, I mean, that seems like clear defamation.
Yeah, I don't really know how else you can.
I mean, if you had to, I don't know, come up with your wildest defense, I don't know what your argument is.
Well, it would be some loony, the cards told me and the cards never lie. And that would have to boil down to, did she really believe that?
I don't actually think that even helps you necessarily.
Well, for defamation, don't you have to know that it is untrue?
No. That is only if it's a public figure.
Oh.
So public figure is when you have to have actual malice.
That's what I was thinking.
If you're not a public figure, you don't have to have actual malice. So defamation per se, as opposed to defamation per qua, if you accuse somebody of a crime, that is defamation per se. So you're presumed that you win on that it's defamation, and then they have to defend against it. And so the only defense would be truth. Or if, in the case of a public figure, you argue that they didn't establish actual malice. But I don't think that this person would be considered a public figure for this purpose.
Demonstrate that the defendant who defamed you failed to fulfill their obligations in determining if the statement was true or not. There's different standard used to establish a defendant's obligation depending on if you're a public figure or a private figure.
Correct.
You only need to show the defendant in your definition was negligent or careless in determining whether the statements were true or not.
Correct.
So it goes to the amount of fact-checking research that they did and if they made any attempt to verify what they were putting out there.
No, because again, that's then a question of whether it's a public figure or not.
Well, it's negligence versus absolute malice.
Actual malice, but yes. And yeah, at the very least, I think you'd have negligence here.
Well, yeah, that's what I'm saying. Like how, but if she believes her tarot cards to be 100% true.
She's still negligent because that's not a thing.
But that's not a thing to you. To her, that's a thing.
Do I still have the ability to share screen? Yeah, this is New York.
I'm just saying, like, if that's a religious practice or something along those lines, and you believe that.
Pop that up. We'll read the statute.
You can't put it up?
Nope. Here, if you want to make it a little larger. A person is guilty of fortune telling when, for a fee or compensation which he directly or indirectly solicits or receives, he claims or pretends to tell fortunes or holds himself out as being able, by claimed or pretended use of occult powers, to answer questions or give advice on personal matters, or to exercise influence or affect evil spirits or curses, except that this section does not apply to a person who engages in the aforedescribed conduct as part of a show or exposition solely for the purpose of entertainment or amusement. Fortune telling is a Class B misdemeanor in the state of New York.
Okay, so it would be whether that was...
That's a straight up crime in New York.
New
That
York is a little
why
more
I
progressive
yeah.
than the Midwest.
Huh?
I'm not sure Idaho is going to have a statute about fortune telling.
No, I genuinely don't know that it does, but New York certainly does.
Yeah. But the professor was in Idaho, and she was in, I want to say she was in a southern state. Yes, we're going to wrap it up because I'm nearly like bedtime.
Yeah, that's fine. I'm starting to fade myself a little bit.
I'm nearly like Ziggy level coma, you know. But thank you for those of you who stuck with us like all freaking day, like WTF.
Yeah,
it's really cool. Judge Dad called. Oh my God. That was really freaking awesome.
Yeah, when was the last time they sat through a 4-hour stream?
Not since I did the Judge Dad marathon stream.
It's been a while. Myself as well.
I love you guys too. I seriously couldn't do this without you. I don't know how I would have survived the past couple months without all of you. You are absolutely amazing, and you make me smile on a daily basis, except for the assholes that put negative things in the chat. But hey, poo on them.
Like
what are you going to do?
Any negativity, send it right my way. I got it. I feed off of it.
Oh my gosh. I did the one the other day on David Chase, and the number of people that put too much talking, too much commentary. I'm like, do you not realize that this is what YouTube wants us to do? And what I've been doing is what YouTube doesn't want us to do. Like, I'm in the process of moving, and everything is like a hot mess.
Yeah, but Maggie, you've seen my stuff from the beginning. How many times have I lost it where it's like, you know what, if you don't like my commentary, you're perfectly welcome to go to Law and Crime Stream yourself and go watch the raw feed.
And that's what I said to him.
Is the commentary.
Thank you. And it is. It's like, if you don't want commentary, go to a freaking non-commentary channel. Like, don't expect us to chop it up and do your work for you and not get paid for it, because that's literally the only way that's going to happen.
Yeah, pretty much.
But there's so many people breaking the rules who are chopping it up, throwing it up there, and not getting in trouble for it. But it's going to catch up with them eventually. And that's why I can't keep doing it. But I did have to take a break and try and do that for a while.
Yeah, we talked about why I needed to take some time away. But no, it's good to be back a little bit. I have a couple ideas on the back burner. So to the folks on my stream as well as Meg's, thank you so much for tolerating me for 4 hours. I hope that you learned something from my commentary on this absolute nightmare circumstance of entitlement in a small town in rural Texas. But the second Meg started sending information on this to me, I needed to comment on it, and I'm hoping that I can get back on a more regular basis. So, Meg, thank you so much for having me. I really do appreciate it.
I am glad you are back. It took a while. I've sent you a lot of stuff, and this is the first one you've jumped at, so I'm glad you did. We are glad to have you back, and we'll keep doing stuff, and we'll stay on top of this one, and there'll be updates. And we'll find some more cool stuff to break down and analyze and all of that, because we're cool. We know it. I mean, look at my dog. Ziggy, play dead. Play dead. Smart dog. Huh? Huh? All right. Everybody have a fabulous evening, and we will catch you soon.
Take care, folks.